I'm only on the
Yes.
point, Milad, that we are in the onset of the holy month of Ramadan. We are in the midst of that, and the festival of Eid is less than a month away. So I was only praying before your lordship whether this demolition exercise may be deferred after the festival of Eid gets over. That is the only point I'm.
See, this order of demolition was passed long back. It is not that it is passed in the month of Ramzan or anything of that sort. This is a very old matter,
23.
and these religious events will come and go. You chose not to vacate in the aid of demolition. Now, what can be done? The corporation people are there ready for conducting the demolition work. And now, if one day gets deferred, the next date, it will be very difficult. How can it be done?
But I submit before your lordship that 18th is the festival of Eid. Tentative date for the festival of Eid is 18th.
Nothing to do with the date. The date is the court's order.
But
The
immediately,
date when the court's order was passed.
but one last prayer, Milad, immediately after the festival gets over, Milad, demolition exercise may start.
Corporation, where from the corporation will find out a date. For you, maybe there is a reason. But for the corporation,
It's true.
for the police, now the
My
election.
lord, we have done compliance, my lord. As per your leadership direction, my lord, we have done compliance.
The election work will start and nothing can be done. You please make arrangements so that the court's order is complied with, and I'm not interfering. Who is for the corporation? Yes. What is the position?
Residential building, my lord, on the previous occasion, we have indicated that these occupants are there. My lord's pleasure was to direct a copy to be served from Mr. Bandobad, so that SSC police assistance be given, my lord.
Today is the date fixed for demolition.
No,
No, it's not, sir.
Not
I
so.
was pleased to direct, my lord, to serve a copy of the petition and the order upon Mr. Bandobadhyay, my lord.
No, that is all right.
For onward
Yes.
transmission to Deputy Commissioner of Police Port. That has been done, my
All
lord.
right. Yes. Corporation.
We fix a date, my lord, with the help of, my lord, the state, my lord, will execute the.
The date has not been fixed. Please come. Learned advocate representing.
It also, this, my lord, the can application being can one, my lord, since in my lord's list is on the pretext that, my lord, he says, my lord, the GT appeal, the tribunal application against the order of the special was dismissed for default. It has been restored.
No, it has not been restored.
Application.
So you want an alibi?
No,
Yes.
I have only annexed the.
Immediately
No,
ordered.
Milad, just to be
He
fair,
referred in 24th. Thereafter, my lord, no steps taken. After repeated adjournments, my lord, matter was
Only to
dismissed.
hold on to the unauthorized construction.
But,
26 February 26, my lord, this restoration was
Is not there.
Milad, what I'm submitting, Milad, I have annexed all the orders, Milad. It has been dismissed. It has not been
You
restored as yet.
did not mention the fact of dismissal of the BT appeal.
I have mentioned and I have annexed the
Right
orders.
now.
Yes, I have annexed in my application.
Right now, did you utter a single word? You didn't.
No, that was
You
dismissed.
only fell back upon the
Yes, Milad,
holy
because that
month.
is the. I have nothing much to say because that was
restoration was
dismissed in
filed about after
2025.
1 year.
Milad, owing to the death of the learned advocate, was conducting the case.
Whatever.
That was dismissed in 2025, not now, Milad. And I have annexed the orders as well.
Learned advocate for the applicant. Na, aage likhun to. An application has been filed by. Are you a party in the writ proceeding?
No, my lord. It is an application for addition of party I filed.
No,
In the contempt application, they have made an application for addition of party.
An application for addition of party has been filed in the contempt application. Stop. The applicant submits that. Applicants submit that they are the residents of the structure which has been found to be unauthorized and is facing an order of demolition. Stop. Submission is made in court. Oral submission is made in court that the corporation has fixed up a date for demolition during the holy month of Ramzan. Stop. Prayer has been made to defer the demolition proceeding for the time being. Learned advocate representing the corporation / contemner submits that the ground for seeking adjournment as submitted before the court is not mentioned in the application. Stop. The application is only for addition of party. Stop. It appears therefrom that an appeal before the municipal building tribunal was filed against the order of demolition, and the said appeal, being BT appeal number 17 of 2024, stood dismissed for default on 11th of April 2025. Stop. The same is yet to be restored. Stop. Paragraph. As in the contempt proceeding, the court is only required to ensure compliance of the order passed by the court, accordingly, the court is not inclined to allow the application seeking addition of party. Stop. The application stands dismissed.
But the original contempt application is directed to appear on
When it
12th
is
of
there, it is there. It will appear in the usual course.
We are grateful, my lord.
Obliged, my lord.
এটা ধরুন তো।
Just excuse me, can it be taken up tomorrow?
Tomorrow?
হ্যাঁ, কোনো অসুবিধা নেই।
Right, not today.
One of the matter has already been. Sorry.
এটা ফেরত দিয়ে দেবেন।
আপনি না নরম হয়ে গেলেন কেন?
রাখুন, আমার কাছে কপি আছে। কপি আছে আমার কাছে।
Responded, my lord.
The applicant.
Lordship, I'm for the petition. Item number 5.
Actually,
Lordship, matter is related to withdrawal amount. After determined, withdrawn amount has been deducted from the amount. Petitioner filed several writ applications before this honorable court, and kindly see last page 37. In reference to your query contained in your letter dated 13th April 2023, this is to inform you that your prayer dated 8th February 2023, along with all answer, has already been forwarded to the District Inspector of School Secondary Education, Postim Bardhaman, by this office memo number such and such, with a request to look into the matter and send a report thereon. But nothing has been done till date.
প্রেয়ারের পরে ক্যালকুলেশন করেছে, কিন্তু ক্যালকুলেশন এক মাস আগে করেছে, 30 জুলাই।
What is your prayer?
Prayer is, Lordship, kindly see the PPO. It is appeared that 1,80,000 some amount has been deducted from gratuity amount. And kindly see page 22. Page 22.
Yes.
In top, noting that house rent allowance, second line, house rent allowance from 8 February 1982 to 30th September 2002, Kalpana Mukherjee, assistant teacher of Chittaranjan MS Girls
High School. The amount is 1,30,914.98 paise on and from 7th May 1982 to 30th September 2002. And kindly see next next page. In top 1st October 2002 to 30th and 31st August 2009. Amount of rupees 49,869. Accordingly, total amount is 1,80,000 some amount. This amount has been deducted from gratuity amount after retirement. I did not deposit any amount to each other.
Yes.
Yes, Lordships. And kindly see page 24. Para
Yes.
Para 4A. HRA drawn by the teacher from 8 February 1982 till 30th September 2002 is to be calculated and refunded to government through Treasury Challan as she resided in husband's quarter.
Yes.
Her husband was also an officer of the CLW, that means Chittaranjan Locomotive Works, Indian Railway, and that person was given rent to the CLW.
Sir, I do not follow your submission. The court twice held that house rent allowance has been rightly deducted. What do you want now?
I am kindly see Lordship's application, my application, page 32. It is my
Yes.
application. That in terms of the letter dated 20th February 2009, Assistant Welfare Officer for Deputy Chief Personnel Officer CLW, Chittaranjan certified that C.A.P. Mukherjee, that means prisoner husband, ex-chief office superintendent of this administration, was provided railway rented quarters for the period from 8 February 1982 to 30th September 2002, and also certified in the letter dated 25th August 2008, issued by senior personnel officers, mechanical, for Deputy Chief Personnel Officer CLW Chittaranjan, that house and allowance not drawn for the period from 1st October 2002 to 31st January 2004. The amount has been taken by the railway authority from my husband and also taken from state government, because I reside with my husband only on that ground, Lordship. And that is reflected in page 24, para 4A.
Page 29 of the writ petition, the court has come to a specific finding that you paid 21,000 rupees in excess.
No, that amount, 21,964. That means, suppose the quarter rent is 1,000 rupees. Subsequently,
So
railway.
suppose the court's order is such, and I'm not going to interfere. Please come.
Yes, Lordship.
The petitioner is aggrieved. Who's for the state?
No, no. My lord, the matter is pending before the district magistrate school, Paschim Bardhaman, my lord.
How long will it remain pending?
Not it will come, my lord.
Now, how long will it remain pending? From 23 to 26? 3 years it will remain pending. What is to be done?
Clearly stated, my lord.
What stated?
DI.
DI is your client, sir. What is your reply? What is the reply to this letter at page 37?
Paying for 1 day accommodation, my lord. Already I have told.
কি বললাম, কিছু বললাম? বাদ দিন, লিখুন তো। The petitioner submits that the district inspector of schools, Purbo Bardhaman, Paschim Bardhaman, is not taking steps in response to the communicating memo dated 31st of May 2023, annexed at page 37 of the writ petition. Stop. Learned advocate representing the State respondents is directed to revert with written instruction. Released 11th of March.
Every service and keeping the record option.
Grateful Lordship.
For the respondent, my lord. Respondent 1 to 3, my lord.
Respondent?
1, 2, 3. Union of
One,
India.
all right, Union of India.
Southeastern Railway.
The school is a, my lord, government-aided Anglo-Indian school, my lord, which has been established in a railway land in the year 1958. My lord, thereafter, my lord, the railways were went on making
Is
charges.
the name of the school anywhere there from the documents annexed?
Yes, yes, very much there, my lord. Now, what has happened, my lord, I am coming to it. It's a very short matter. My lord,
Okay, 1, 2, 3.
the writ petition is,
No, you
my
know-
lord. What has happened, my lord? It's but education upon all the students of the Kharagpur. And now, what has happened, my lord? In the meantime, the railway administration has issued certain demand notices against us, saying and putting us under the classification of a private school. Whereas from the documents from page 106
What
onwards,
the school?
it's a government-aided Anglo-Indian school recognized under the code. My lord, if your lordship kindly see the code for once,
So right now the
page 160.
railways want to remove you from there?
No, my lord, they have charged, they have enhanced the land license fee to an exorbitant and astronomical hike by asking us to make 37 crores of payment, where under the rules, my lord, we are exempted from making such payment because we have been listed and we have been recognized as the government-aided Anglo-Indian school. So that charge is not applicable on us, and we have categorically stated in our representation on every occasion. My lord, kindly see their response at page 195.
There means the railway response.
Railways response.
All
Page,
right,
page 195. It's a volume 2, my lord. It's there in volume 2. That may I read, my lord? Representation regarding the above subject under reference has been received from the principal of St. Agnes School. In reply of the above reference letter following are furnished below. As per para number 2 of the land license agreement, annual rent was fixed at 12. Regarding charging of land license fee, Railway Board has issued wide letter dated such and such for revision of nominal license of railway land, leased, license to Kendriya Vidyalayas or all other schools and welfare organization, copy attached. No documents have been attached by the principal St. Agnes School in her letter number such and such in support of KVS government school. Accordingly, land license fee up to 2022-23 had been demanded by this office letter number such and such based on Railway Board circular number 2023. After sending repeated demand letter and clarification of the demand letter, school authority paid license fee for 2013-14 on date 2025-2024 and for the year 2014-15 on date 3rd of December 2024. Railway Board has issued a policy guidelines, my lord, kindly see, for charging land license fee and schools has been classified as government aided and private schools, as no documents has yet been submitted by the principal St. Agnes School in support of government aided school. This office raised a demand why it's such as considering a school as a private school. And in this demand letter, land license 19 crore, liquidated damage 12 crore per month for delayed period of GST amounting 34 crore had the land license fee paid in time. Liquidated damages could be avoided. As a land license fee up to 25-26 for occupation of railway land Kharagpur has been sent as per existing Railway Board policy, request for withdrawal of the same cannot be considered. But kindly see the code for once. 161. 161. The code has clearly said that we are government aided. Clause 5. Subclause 1. It is under the code that we are coming. Page 161.
Aided school means
Yes.
recognized.
Aided school means recognized school receiving aid of any kind whatsoever on a recurring basis, whether in the form of government grant or dearness allowance or the like. An Anglo-Indian school means an institution including all standards and divisions thereof established under the Code of Regulations or European, now Anglo-Indian school in Bengal, now West Bengal 1920, here and after referred to in this code as the existing code and continuing as such on the date of coming into force of this code, provided that such institution continues to fulfill the condition of recognition laid down in this code, particularly in regulation. My lord, kindly see page 100 and
Show me any document that
106, my lord, kindly see.
aided.
Page 106.
If you have documents, why
All documents were
give it to
submitted,
the,
my lord. All
authority?
documents were submitted. I will show another letter, my lord. It will say that we have submitted documents. But they are
1 minute, 106.
106.
It is 2002, fixation of pay in terms of ROPA.
Addressed to the, my lord, in the bottom, lordship will find it has been addressed to the principal St. Agnes School, Kharagpur, by the DI. Now, next page also, my lord, kindly see, it has been issued from the Government of West Bengal, Director of School Education, Anglo-Indian Schools.
Yes.
The same as it is stated in the paragraph 2, and whereas the provision as referred to in Regulation 20 of the Code of Regulation for Anglo-Indian and other listed schools 1993 can be relevant to then pay scales in respect of the government-aided schools affiliated to the West Bengal Board of Secondary Education, which means ROPA 90 and not any pay scale. Well, this is also has been issued to us.
Do you maintain accounts?
Yes, we maintain accounts. Kindly see page 73.
74.
Page 73, my lord, kindly see. This is a certificate.
1955.
54.
Yes, from
55.
Yes.
Thereafter,
And
is
we are
it
getting it.
continuing?
Continuing all
Where
documents.
is the
Next page, my lord, kindly see.
2001 submission
74.
of bill for government DA for the period March? All right, this is 2001. Then later on,
76A.
76A.
all are there.
All are there. All I have annexed. All I have submitted.
77
Kindly see page 77 also.
recognition
Recognition.
of my higher secondary school. Yeah.
Recognition of St. Agnes Convent, Kharagpur as a higher secondary school. And thereafter, my lord, I have annexed all the documents which shows that we are DA getting.
Senior Cambridge. It is 1959, 77.
Still then we are getting it. Kindly see, my lord, DA getting certificate, page 168.
All right.
93, please.
Prior to that, my lord, kindly come to 90.
Grant in aid 2014 category. Where is the name of your school in page? All right, St. Agnes, Kharagpur. The railways?
Yes, my lord, I am applied for
Only
the
another aspect, my lord, one aspect. Kindly come to page 197 for once. My lord, kindly see page 197, what they have stated. Representation regarding the above subject under reference has been received from the principal St. Agnes School. In reply of the above reference letter, it is to state that the principal St. Agnes School has submitted documents of DA grant only, but not submitted any documents of government recognition as government aided school. It's already there in the code. Accordingly, request for reconsideration of land license fee demand and reclassification of St. Agnes School as government aided institution cannot be considered. Therefore, it is requested to arrange the pay the demanded license fee as raised by such and such to avoid further charging of liquidated damages. And thereafter, my lord, page 198, they have threatened us that we will take up the land and we will take coercive action. Page 198. Last 3 lines. Under the code, we are recognized. We are getting DA on recurring basis.
And our faculty has been approved by the
And our faculty has been approved by the government of West Bengal.
that is the rules.
And they are charging us, my lord, exorbitant. The entire school will collapse with 5,000 students.
State we have already made payment subject to prejudice, without prejudice.
may be permitted, my lord.
Yes.
First of all, my lord, my lord, first of all, the school, my lord, the railway authority already asked for the document. They didn't submit any document as per my instruction. The St. Agnes School, my lord, we the railway board directions, my lord, only the government schools and the government aided schools. Private schools are not under the under the periphery. So at that point of time, my lord, the school has not provided any document to that effect.
Now the documents are annexed with the writ petition.
My lord, that has to be, my lord,
Check up and
that
come
should
back.
be considered, my lord. We have claiming, my lord, from the 2013-14 to up to 2025-26 after the railway board direction, my lord, the guideline. My lord, in between, my lord, they have not paid, my lord, the enhanced amount, my lord.
Whether they are liable to pay or not, please check
Yes,
up.
my lord, they have liable, my lord. I have to produce the document, my lord. Thereafter, I submit the affidavit on that effect, my lord. So
I
that,
will not require an affidavit. Look at page 161.
yes, my lord.
What does the aided school mean?
161. Notification. Yes, my lord. The aided school means a recognized school receiving aid of any kind of whatsoever on the receiver recurring basis, whether in the form of the government grant or DNS allowance or the like.
That means he has annexed documents to show that DNS allowance is being given.
Only, my lord, the has.
How does it matter? Only or something else?
My lord, kindly, my lord, then my lord, kindly comes, my lord, page number, my lord, 35A once, my lord. My lord, the below portion of the, my lord, the page number 2, whereby, my lord, kindly comes on the, my lord, the paragraph D, CD, to observe and perform all such rules and regulations and directions of the railways and or the station committee at Kharagpur as shall for time to time be prescribed or he is in the force of Kharagpur as regarding the sanitation, general health and other related affecting of the Kharagpur railway settlement. My lord, thereafter, my lord,
What are you reading? Page 70.
page 35A, the below portion, paragraph number 2.
Yes.
If the demised land is needed for any purpose and other than the specific purpose or the purpose which is the grant of the licensee fail to comply with any of the terms and conditions herein and on the here of the part of the performed and observed all or in the event of the default of the licensee is paying the rent reserved herein before, the lease will be intermined ipso facto and automatically and be demised land shall be liable to
Where
be resumed.
is the
Yes.
where is the default? You tell me, where is the default?
But
They have
default-
not paid rent.
No, they are not paying the rent as per the
How
railway
much?
board guideline, my lord.
What is the guideline?
My lord, railway board guideline, my lord.
12 rupees it was read out.
No, my lord, that has been enhanced, my lord.
How
Thereafter,
much? How much?
my lord, enhanced.
68.
My lord, enhancement. We have made a demand letter of fees of rupees, my lord, 19 crore 16,64,569.
19 crore is the rent.
No, my lord, the enhanced amount from the, my lord,
How
2013.
are you enhancing? Relying on what?
That is the dispute.
And upon that effect, my lord, we have to, my lord, the document and have to consider the document so that, my lord, I have,
That is the disputed.
my lord, I have to press this document before the court, my lord. I have to seeking the document, my lord, except the DA, whether they have,
Your submission is from the documents
Yes.
that have been read that since the school could not produce documents, you could not ascertain
Okay.
whether the school is recognized or not. Now there are enough documents annexed to the writ petition.
Yes, my lord.
Go through it, check up what the rule says, the aided school, and then you come back with a report.
Obliged.
All right?
Obliged.
My lord, may I stay that
All right.
one notice, my lord, at page 198.
My lord, kindly
The petitioner,
to give me some, for the time being, my lord, give short date, my lord. I will prepare, man. I will prepare the document and come.
I'll give you the shortest date as per your choice. Do not do anything. The date is up to your choice. You say when you will come back.
My lord, 2 weeks, my lord.
Very well. Do not do anything. The petitioner is petition number 1 is an Anglo-Indian school running from the leased land of the railway. Stop. The petitioner number 2, now 2, 3 and 4 are the officials of the said school. Stop. The school claims to be a recognized government-aided Anglo-Indian school imparting education to the only the girl child possibly co-ed
Co-ed school.
imparting education to children in the in Kharagpur. Stop. The petitioners are aggrieved as the railways have demanded exorbitant amount which is absolutely beyond the capacity of the petitioners to pay. Stop. Submission is that the school is not liable to pay such amount in terms of the code of regulations for Anglo-Indian and other listed schools, 1993, published by the State of West Bengal, Education Department, Secondary Branch. Stop. ঠিক আছে? Next. According to the railways, despite request, the school failed to produce any document in support of receiving financial grant from the government. Stop. The prayer of the petitioners for withdrawal of the impugned land license demand fee, impugned land license fee demand, and reclassification of the school as a private one has been refused. Stop. Next. Prayer has been made to set aside the impugned order of the railways and permit the school to run in the same manner as it was earlier. Stop. Paragraph. Learned advocate representing the Union of India submits that as the petitioners failed to produce supporting documents. Accordingly, the railways raised the demand upon the petitioners. Stop. Paragraph. The Learned Council for the railways seeks time to revert with instruction. Stop. Paragraph. It appears that the petitioners have annexed enough documents with the writ petition in to suggest that the school is receiving grant from the state government. Stop. As per clause 5 within bracket 1, English 1 of the code, an aided school means a recognized school receiving aid of any kind whatsoever on a recurring basis, whether in the form of government grant or dearness allowance or the like. Stop. In the instant case, there are documents evidencing the fact that the school receives dearness allowance from the government. Stop. Despite availability of such document, whether the school can be treated as a private school or not is to be adjudicated. Stop. Next. To allow the railways to revert with written instruction, hearing of the writ petition stands adjourned till 11th or 18th.
My lord, kindly make it 17th, my lord.
All right, 17th March. The learned advocate representing the railways shall produce a report from the railways signed by a responsible officer disclosing its stand. Apropos, not apropos, on consideration of the documents annexed to the writ petition. Step. If required, comma, the railways may provide an opportunity of hearing to the petitioners for production of any further document. Stop. Released 17th. Stop. For the time being, comma, the railways are restrained from treating the school as a private institution. Services taken on record.
Oblige, my lord. Great.
তাও আমি লিখে দিয়েছি
Pradeep. And not to press the impugned, not to press the demand impugned in the instant writ petition.
7 I appear for the petition.
7.
Lord, I am for the statement.
Right here, the petitioner, that is a teacher of a delegating school. I moved to writ petition seeking approval of my appointment. Pursuant to the order passed by the district inspector of schools, the approval of appointment was made, but since 2024, I was appointed in the school in 2010, and my service was approved after completion of the probationary period in 2012. The school is in Borobajar. Now, the case of the petitioner is, the moment the writ petition was filed, kindly have a look to page 42. This is the approval of appointment. My name comes at serial number 1.
Yes.
2, 3, and 4. I have filed 3 writ petitions before your lordship. I don't know why the other matters have not come. In the one mentioning slip, I have put 4 numbers. Same matter. Now, by this order of approval, my appointment was approved since 2024. Got it? 4th of October 2024, date from which the approval is effective. Past graduate teacher. Now, the moment the writ petition was served, the approval was made. The writ petition was finally disposed of, page 43. As well as the grievance of the petitioner is redressed. Now, the grievance in the present writ petition.
In the earlier writ petition, you sought for approval.
Yes.
And page 42 is the approval letter.
Yes.
All right.
It was served on the DI, but DI passed the order of approval.
And this order was placed before the
Court.
appropriate bench.
All right. Then
Yes,
what
yes,
happened?
That is why Justice Bhattacharya passed this order. Now, in the instant writ petition, what I am on is, if your lordship kindly have a look to my initial appointment, kindly turns to page 20.
What is your prayer?
My prayer is, my appointment should be there since my appointment was approved by the school after completion of the probation, page 21, since 2012. Because I lost 12 years. Kindly have a look, page 21. This appointment was confirmed, my service was confirmed by the school on 26th of July 2012 by the school management. Now, in the order dated at page 42, the DI has taken away my 12 years of service. So, I pray before your lordship, kindly have a look to page 36. This is the recent order passed by the principal secretary of 3 teachers of the same school, where the principal secretary had granted approval and the financial benefit to all those 3 teachers from the date of their initial appointment. Kindly have a look to page 38.
36, Monju Pandey, is she of the same school?
Same school, Balika Shikha Sadan.
All right.
Same school. She is still in service. Now, your lordship kindly have a look to page 38. Manju Pandey, the date of appointment, middle portion I got the chart. Date
Yes.
of appointment of 1st of January 2010. Now, the page paragraph 5, having considered the facts and circumstances of the case, relevant records of the case, submission of so and so. This is to state that Balika Shiksha Sadhan, Kolkata, but I am a teacher of this school, is a DA school recognized by the board, which receives DA component for its approval, approved staff of the school from the state government. In the instant case, the petitioner Manju Pandey having qualification of so and so was appointed as assistant teacher by the concerned school authority with effect from 1st of January 2010 and so respectively. Subsequently, their appointments were confirmed by the concerned school authority from 1st of January 2012 and so respectively. Under the present factual situation, it is stated above, and considering the relevant provision and observation of the Honorable Court at Calcutta, be the order dated so passed in the instant matter thereafter, as well as considering the Honorable High Court Calcutta order dated so date 2013, that I am not reading it, wherein a direction upon the DI concerned to approve the petitioner's appointment after condoning the age bar, I am inclined to accept the prayer of the petitioner to grant approvals of appointment of the assistant teacher of the concerned school on taking human approach instead of enforcing rules in strict fashion. Accordingly, the DI of schools concerned is directed to take necessary step for according approval of appointment in favor of two petitioners, namely so and so of the concerned school, and release all area DA as admissible to the petitioner forthwith and submit action taken report.
But then the date from which it is approved is not
But
mentioned.
all area DA means from the initial date of approval.
Has that been?
Yes. But I appeared in those matters.
Initial date means 2010 or 12
Yes.
from that date.
Yes. And the only difference is in these two cases they were overaged. They have kindly have
condonation of the age bar.
Age was also condoned.
Yes.
So they got this benefit. The principal secretary got the release this benefit. This order was placed before the DI. In spite of that, but the DI did not take any action. So may I request your lordship, if the matter can be sent to the district to the principal secretary. He is the highest.
Oh, 1 minute. Yes.
My lord, there are so many factual aspects involved in this matter. My lord, I want to file affidavit.
Factual aspect.
My lord, the previous order, which is the my lord honorable court's order that they after getting the BA degree, his BA will be considered. But that was not done here.
What has the degree got to do with this?
My lord, kindly come to my lord.
He showed the order of Justice Sharaf.
Yes, Justice Sharaf, my lord.
Page 30. I did not have the.
Tell me one thing, or you file a report as to where from you got this date, 4th October 24.
Yes, I can file.
All right.
Yes.
The petitioner is aggrieved by the act of the District Inspector of Schools, Secondary Education, Kolkata, in according approval to her appointment on and from 4th October 2024. Paragraph submission is that the petitioner was appointed in the year 2010 and her service stood confirmed by the managing committee of the DA getting school where she is teaching, that is Balika Shiksha Sadhan, on 26th July 2012. The District Inspector of Schools accorded approval to the appointment of the petitioner on and from 4th October 24 instead of 26th of July 2012. Prayer has been made to direct. Now, the petitioner has annexed documents to show that similarly placed teachers were granted approval by the order of the Principal Secretary.
Yes, School Education Department.
School Education Department on and from their initial date of joining, initial date of appointment. Stop paragraph. Prayer has been made to direct the authority to accord approval to the service of the petitioner since 2012. Stop paragraph. The District Inspector of School Secondary Education, Kolkata, is directed to revert with written instruction as to why the appointment of the petitioner was approved on and from 4th October 2024 and not from 2012, the day when she stood confirmed in service. Stop. Let the instruction be placed before this court on 18th of March.
No, whether it filed on affidavit or only
Give
report.
written
report.
instruction. We'll see.
Let me hand up 3 other writ numbers. Same school, same teachers, but same approval, one approval. All the matters are there in the monthly list. 3 numbers are there.
আর দুটোকে দিয়ে দেবেন, নম্বরগুলো তো রয়েছে।
I'm grateful.
Lord, I am for the petitioner. Lord, it is that matter of HRA where your lordship has already considered in light of the previous judgment that when the husband is in private concern, they are entitled to get the HRA. This is your lordship's order, my lord, on the previous occasion. Only one.
Prayer been refused.
Yes, I tell you, lordship, my lord, by prayer, kindly come to page 102.
Yes.
My lord, it is the DI has sought kind of instruction from the school. And school has already given its.
For Momita Datta.
Yes. 102, my lord.
Petition of admissibility, petitioner's claims.
That is settled. এটাতে মৌসুমী বিশ্বাসে সেটেল হয়ে গেছে এটা। এটাতে করে দিয়েছি। হ্যাঁ ওটাই পাবে, ওটা অনুযায়ী তিনি অর্ডার করছে। And page 101, my lord, school has already forwarded all the documents.
101 date.
But 101 was in September and 102 is in November.
Yes. After that, my lord, it is pending because in light of Moushumi Vishwas's judgment, my lord, I am entitled for that HRA. I have also made
The claim has not yet been settled, I see.
not yet
Since
been
the
settled. That is why my
application
prayer
forwarded
is in terms of this Moushumi
Where does your husband work?
PricewaterhouseCoopers.
All right.
It's a private concern. My lord, in light of this judgment, my lord, my claim may be considered. One thing, my lord, I must tell you, lordship, it is my responsibility to tell you, lordship, petitioner is a candidate of 2016 job loser untainted candidate. So I must draw this attention, though it will not affect my entitlement of HRA because the Honorable Supreme Court has allowed full salary and all benefits up to 31st of August 2026. I just informed your lordship, my lord. So in light of Moushumi Vishwas, my lord, my prayer may be considered.
Yes.
Let there be a decision of the authority first.
Yes, yes.
Because yes, the lordship kindly sees page 102, the 7th of November, it is addressed to the school authority asking for certain clarifications. So as to in the matter of grant of HRA claim of the petitioner. That is under consideration. And my lord, this
Consideration taken.
yes, that should have
And let school cooperate with the DI also, my lord, because some instruction may be required from the school also.
Since the application.
Did you ever receive HRA? No.
I had to return that HRA. That I have category 2 months I received. Then I had to return for 1 month I had to return. And since then it has become 0. My lord, I have categorically stated in the paragraph, it is there, my lord, in paragraph 3, I have stated, initially for 2 months received house rent allowance from the date of her appointment to the tune of rupees 1,913. However, from February 2020, the house rent allowance as duly received by the petitioner so far has been abruptly stopped and became 0, for which the petitioner is deprived of receiving her house rent allowance as admissible under law. Then during ROPA calculation, one HRA was given to me that I had to return by TR Challan form. That is at paragraph number 4. The petitioner states that since the husband of the petitioner,
Right, this order possibly will be.
it's only one change is required, possibly, my lord.
Yes.
Subject to correction. এই জজ সাহেবেরই order আছে। এই যে, একটাই আছে। My lord, that representation is pending, possibly
The representation in this case is.
Here it is mentioned yet to make representation. This is not required.
yes, that is not required because the DI has already proceeded based on my representation. My lord, in light of Mousumi, my lord, kindly let it be decided.
As soon as the school authority furnishes, my lord, the details as asked for, the decision will be taken.
And this will not be a bar for me. It's being an untainted candidate will not be a bar for me.
এক থাকছে, দুই থাকছে, তিন থাকছে, চার থাকছে, পাঁচ থাকছে।
হ্যাঁ, ওইটুকুই চেঞ্জ হবে, বাকিটা সেম আছে। এইটুকু খালি চেঞ্জ হবে, আমার ক্ষেত্রে করা আছে রিপ্রেজেন্টেশন।
ছয় থাকছে। 7 নম্বরটা লিখুন। The District Inspector of Schools, Secondary Education, Nodia, video communication dated 7th November 2025, has sought for clarification of admissibility of the petitioner's claim of area HRA from the head of the institution. There is no response either from the end of the school or the District Inspector of Schools. The petitioner prays for a direction upon the District Inspector of Schools for releasing area HRA
as well as regularization of the HRA
and regularization of our HRA
sought for interest
as laid down by the court in the matter of Moushumi Biswas within bracket Supra. Paragraph. The instant writ petition stand disposed of by directing the District Inspector of Schools, Secondary Education, Nodia, to take a decision on the prayer of the petitioner for grant of area HRA and for regularizing her current HRA strictly in accordance with the law laid down in the matter of Moushumi Biswas within bracket Supra at the earliest but positively within a period of 12 weeks from the date of communication of this order. Nine will remain. 10 will remain. একটা add করুন. It will be open for the District Inspector of Schools to provide an opportunity of hearing to the petitioner if required for production of documents in support of the submission that her husband works in a private organization.
Lord, I prayed for a declaration that I being an untainted teacher will not be a bar.
Let them take a decision. This is not the issue.
Complicate the issue.
Yes, do not add up things. To take Moushumi back.
Yes, I'm grateful to
Lordship.
Lordship. The interest, your Lordship.
I've mentioned whatever is there.
Area and
whatever is there in the order, 5% interest on the areas that has been mentioned.
But I appear on behalf of the petitioner.
Yes.
So this is relating to the higher scale of pay.
All points are left open, my lord, because they have made certain statements here.
It is, I have not, all points are
left open.
The court has not decided anything.
Normal evidence have not been called for, so allegations in the petition
as the petition is disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents. Right, next.
The petitioner was appointed as assistant teacher in geography under honors oblique PG category. He joined on 10th December 2013. So thereafter, upon obtaining permission from the DI of school, she pursued her study the master degree in geography.
What do you want? Higher scale of pay?
Higher scale of pay from the declaration of the result of I made application, it is pending before the board also granted permission for study leave. That was also granted.
The
My
petitioner
last
is prayer
representation, page
seeking
34.
higher scale of pay
Page 34.
on enhancement of his educational qualification is pending consideration before the District Inspector of Schools, Secondary Education, South 24 Parganas.
Response number
Do you
3.
have any instruction? Acha. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition stands disposed of, directing the DI, SE, South 24 Parganas, to take a decision on the petitioner's prayer, strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be provided to the petitioner for production of all documents in support of her claim. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the claim of the petitioner is allowed, comma, the necessary consequential steps shall be taken without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation dated 29th November 2025 along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed service is taken on record.
Only one thing, not if the required, the school authority will the assist if any requirement is.
The school is directed to render all necessary assistance and cooperation as regards the claim of the petitioner.
Grateful, Your Lordship.
State, my lord, I am for the petitioner. Is the affidavit of service.
For the state, my lord.
My lord, petitioner was in the CPF, the first occasion. In the year, my lord, 2014, he opted, my lord, CPF scheme. Page 23, your lordship will find the option, form of option. And thereafter, page 24, the calculation has been made and it has been authenticated 5,67,000. And in the next page, TR form, my lord, page 25, I have deposited on 2016 of the government share. My lord, it has been authenticated in page 26. Your lordship kindly have column number 3.
Yes.
My lord, 5,67,000 government share I deposit along with others. Now, it was also deposited to the District Inspector of Schools. But there has been a delay on part of the, my lord, District Inspector of Schools. I have made several representations. On page 41, your lordship, my lord, the DI has passed an order that it is because of the ADI office, the authentication was late. That is why, my lord, the conversion has not been made. I was already in the service. I retired on June 24, sorry.
23.
30th June 2023. My lord, in the fourth line, the ADIS Kharagpur has authenticated his CPF calculation sheet on 24th February 2016. And the incumbent ultimately
page
41.
Yes, 41. I can see authenticated 6th of February.
2020 February 2016, and the incumbent ultimately deposited the government share on 30th March 2016, amounting of rupees 5,67,000 such and such. Now, which was beyond the stipulated period on they in 2014. Now, my lord, in the next page, page 42, your lordship will find the explanation was given from the DI. With reference to the above, I have honored to submit that the cause of delay occurred on occasion of the additional district inspector to AC under Kharagpur subdivision for processing the deposition of the government share. It is not the petitioners who has delayed. Now, my lord, the next page I wrote to the principal secretary. Now, deputy secretary wrote to the principal secretary that the prayer for Gautam Mandal assistant teacher is directed to above mentioned matters, requested to kindly take accordingate action. Though, my lord, there is a judgment, I will come to later on. There is already Mukti Pal's judgment. If it is deposited, it has to be given. Now, I moved the writ petition earlier, my lord. Page 47 onwards, and the ordering portion, my lord, on page 49. The court finds it's up to direct the principal secretary, Government of West Bengal Education, response number 2, to decide the issue whether petitioner at this stage be permitted to get
benefit of general provident fund of pension GPA scheme on accepting the delayed pension from calculated the state authorities after authentication was made by the concerned additional district inspector of AC Kharagpur within a period of 6 weeks from the date of communication of this order. An opportunity of hearing should be given and during the decision has to be taken. Now, my lord, I have been called page 52 and page 53, my lord, again, some clarification has been asked from the DI and DI has given the authentication. Under such circumstances, your good safely requested to do the needful sanction of the pension in favor of Gautam Mandal, retired assistant teacher. But still it is pending for issuance of pension payment order. Again, page 54, my lord, it is also from the additional district inspector of school to the head of the institution. These letters are going on, my lord. Your lordship has decided the issue, my lord, is on Mukti Moipal, my lord, in a similar occasion, my lord. On June 2024, I am still waiting even after deposition of the amount. Kindly have a look, my lord, your lordship's order. This is not also a regular case. This is also, my lord, the sum was deposited.
Page 25, the
Yes.
treasury challan.
Yes.
It appears that it was deposited in 2016, isn't it?
Yes. That is why, my lord, it was been authenticated on page 26. These
Page
are the
24, 1 minute, let me understand. Page
Yes.
24
yes,
is the calculation
yes,
that this much you are supposed to pay.
yes,
This was within time,
yes.
but you paid it in 25, page 25 in 2016.
Yes, I paid on 2016 because of the authentication, delay of authentication by the ADI Kharagpur. That has been reflected in the next page. Page 27, it was deposited in the same time, 12 September 2014. In the school peon book shows the government share. Now, your lordship, I have already, my lord,
Page 27.
page 41, your lordship.
1 minute, page 27, what you want to show?
Well, it was deposited in September.
Submission of the government share of CPF refunded.
Yes.
Refundable account.
Yes.
From Gautam Mandal. It does not mean
Yes.
that the money was actually transferred.
Yes, exactly. That is true. Because the authentication has to be made. Otherwise, I cannot deposit. Page 41 is the valid answer. Page 41, your lordship's query. Kindly have a look. Fourth paragraph, page 41. The school authority has submitted his calculation sheet of CPF with accrued interest to the ADIS Kharagpur on 12 September 2014. That is within time. For authentication, ADIS Kharagpur has authenticated his CPF calculation sheet on 24th February 2016. And the incumbent ultimately had deposited the share on 30th March 2016. So, my lord, there is no fault on part of the petitioner. It is also reflected in the next page, page 42. This was delayed because of this reason, because it has been submitted delayedly. Page 42. Kindly have a look. With reference to that, I have honored to submit that the cause of delay occurred in occasion of the additional district inspector AC under Kharagpur subdivision for processing the deposition of the government share of CPF money. It is not the petitioner. This has been authenticated by the DI school AC Paschim Medinipur. So, let
me hear your submission.
Yes.
I'll have to take instruction. What is the fate of the hearing? That is also not annexed.
Which hearing?
As per the order of this honorable court. Page 49. Within a period of 6 weeks.
Page 53 and 54 is the communication letter.
In date of communication of this order, an opportunity of hearing shall be granted to the petitioner or his representative. Then a notice has been sent that on page 52.
And 53?
52, 25th of July 2025 at 12 noon. The hearing will take place. My lord, that has not been annexed. I have to take instruction. My lord.
No, page 53.
What is the fate of the whether
fate is I have annexed.
This is not the order. It a key. It a to request.
Terms, my lord,
that was direction was passed to the
in compliance of the Honorable Court order with reference to the, I have honored to submit that the pension case in respect of Gautam Mandal, retired assistant teacher, physically along with relevant documents are attached herewith for ready reference for sanction of pension in favor of Gautam Mandal, retired high school teacher. Under the above circumstances, your good self is requested to do the needful.
Please come. The petitioner.
My lord, may I make and another submission, my lord? My lord, be that as it may, whatever facts, my lord, after Mukti Moipal's division bench judgment, my lord, there is no, my lord, delay should be occurred by the respondent because I am the, my lord, incumbent. I have deposited the amount long before.
My lord,
Long before means 2016.
Yes.
2016.
Yes.
Not
But
14.
even today they are accepting by virtue of your lordship's court's order.
Yes, yes.
That is,
but then 2016. The petitioner is a retired assistant teacher of a high school. Stuff. He opted for the GPF scheme. Velikunta opted for the opted to switch over to the pension, including family pension from gratuity scheme. In terms of the notification dated 13th June 2014. Stop. The contributory provident fund amount that was required to be refunded by the petitioner to the state was calculated on 14th August 2014 and the same 14 by the head of the institution, and the same was forwarded to the District Inspector of Schools, Secondary Education, Paschim Mednipur for authentication. Stop. The authentication was done by the ADI on 24th February 2016. Stop. It is only thereafter that the petitioner submitted the amount in the treasury
on 30th March 2016.
On 30th of March 2016. Stop. Due to the delay on the part of the respondent authorities in countersigning the calculation of the figure which the petitioner was supposed to refund to the government, his pension file has not been made ready. Stop. The petitioner made repeated representations and also approached this court by filing a writ petition being WPA 12940 of 2025, page 47, which stood disposed of by the court on 3rd July 2025 by directing the Principal Secretary, Government of West Bengal, to decide the issue as to whether petitioner may be permitted to get the benefit of the General Provident Fund with pension on accepting the delayed payment of the sum as calculated by the Stop. The care of the petitioner was considered and The District Inspector of Schools, with a communicating letter dated 27th of August 2025, forwarded to the Director of Pension, Provident Fund and Group Insurance the pension file of the petitioner for sanction of pension in his favor. Stop. Till date, the pension payment order has not been issued. Stop. The petitioner is aggrieved by the same. Stop. Prayer has been made to direct the authority to issue the PPO in his favor. Stop. It has been submitted that there was no intentional delay or laches on the part of the petitioner in refunding the amount calculated by the head of the institution. Stop. The delay took place at the end of the ADI within bracket SE Kharagpur. Stop. Next. Now the petitioner ought not to suffer for any delay on the part of the respondent authorities. Stop paragraph. Learned advocate representing the state is not ready with instruction. Stop paragraph. As it appears that the petitioner has annexed documents in support of the submission that he opted for pension within the stipulated time period, and a calculation of the amount was made and forwarded to the state respondents for authentication in proper time, accordingly, the petitioner ought not to suffer on account of the delay on the part of the state respondents to authenticate the calculation forwarded by the head of the institution. Stop. The petitioner has annexed documents to suggest that the District Inspector of Schools, Secondary Education, Paschim Mednipur, in the communicating letter to the Deputy Director of School Education, dated 1st of February 2023, admitted delay in authentication in the office of the ADI. Stop paragraph. Under such circumstances, the authority ought to accept the amount that has been refunded by the petitioner and permit him issue pension payment order in his favor. The all papers for grant of pension and issuance of PPO has been forwarded by the District Inspector of Schools to the DPPG. Stop. The DPPG, by further communication, DPPG is directed to take steps for issuance of PPO in favor of the petitioner. For grant of pension on and from the next date of his retirement.
Great.
The District Inspector of Schools and the head of the institution are directed to cooperate with the DPPG for making the pension file of the petitioner ready without any further delay. Stop. DPPG shall ensure that the PPO is issued in favor of the petitioner positively within a period of 6 months from the date of communication of this order. With petition stands disposed of. Affidavit of service taken on record.
No, instead of
Return.
6 months, you will have to kindly 3 months.
Next.
11, my lord, I am for the petitioner. The case of the petitioner, my lord, that petitioner was once granted 3% additional increment, and then he was asked to deposit the amount that is on page 47, and then the pension payment order issued. My lord, I have come to your lordship's order, my lord, subject to your lordship's sanction. But I have to deposit a sum of rupees, my lord, 3,44,464. And then, my lord, the pension payment order issued on page 48. Page 22 is the sanction of the DI initial.
Are you there for the state?
Lordship's order.
Where is the 3% additional increment that you are getting over here?
My lord, kindly have a look, page 22, my lord.
No, page 47 is the TR Chalan.
Yes, refund the excess overall salary from 8 to 12 and then 12 to 19 under RUPA 2009 and on from 1st March 2010 to 25 under RUPA 2019.
Right. So it's a ROPA, the 3% increment.
My lord, the reason for ROPA now has been rejected. Now your lordship is getting those 3% increments that the headmasters are not intend to play because of ROPA 19. That is the reason here my lord decided.
ROPA 19 comes later on, but ROPA 9 is also there.
Yes, ROPA 9 is also there, but
And
ROPA
so
19
it's not necessarily because of only 3%. There are other calculations also.
There are other calculations also. That is why, my lord, I paid the 3% increment. If I get that will subsert, my lord, all. I will get the, my lord, amount. When I got through your lordship's order, para 8 of your lordship's order, petitioner has refunded the amount in excess of for his entitlement. That I have, page 22 is the approval order. And then I have deposited the same. And then I have been granted the PPO without giving 3% additional increment. That is why, my lord, I have not filed an overdone, my lord, case because I cannot get a refixation in that case, my lord. It was deposited after the retirement.
The petitioner was serving as a headmaster?
Was serving as a headmaster. retired on 31st May 2025. Refunded on, my lord, 30th June 2025.
Which DI is this?
My lord,
Jhargram.
BISC Jhargram. Page number 4.
Show me your refixation by the DI.
Page 22. Due to upgradation of HS school.
Ninth of September 2013.
Yes, my lord.
Same one. After correction.
The number 12 is also same.
In this matter, I am the state respondents.
Any instruction?
My lord, no instruction, but my lord, prima facie, my lord, your lordship. In this case, my lord, prayer is for granting 3%
Alright,
additional
let him
increment.
make his place his case first, then
Yes,
Page 24 is the, my lord, refixation. Page 24. Due to HS school, my lord. Then this is the audit observation on page 49. Column number 2, my lord. Would be 28,530 instead of 29,330 is requested to recast pay with effect from 1st July 2012. That is the date of upgradation of the school. Then page 50, my lord. I have deposited the amount in terms of, my lord, observation. Overdrawal in salaries of Sri Amitabh Pahari, HM of the school for the period from 1st July 2012 to 30th June 2025, up to retirement, my lord. I am getting the scale. And I have deposited the same on, my lord, June 2025, 12 June 2025. And in the next page, my lord, your lordship will find, my lord, the PPO has been issued.
Yes. What is the submission?
My lord, in prayer, my lord, he has submitted, my lord, he submitted that, my lord, 3% additional increment, as well as, my lord, the release of the overdrawal amount. So, my lord, if your lordship granted 3% additional increment, there is no, my lord, no doubt at all, my lord. But in, my lord, they have deposited the amount
and objection raised before the retirement. Kindly see the letter of the school authority, page 48. That kindly see 48. This is letter, Lord, prayer for verification or authentication of calculation of overdue in salaries of the petitioner for the period of 1st July 2012 to 30th June 2025. Lord, before the retirement, yes, before the date of retirement, it was raised. So therefore, the amount whichever has already been deposited, that is the overdue amount. There has not been, Lord, subsequently, the court has, court has the power, but the prayer in one hand, Milord, the 3% additional increment, and in other way, he is seeking, Milord, to release of the overdue amount which he has already been paid, and Milord,
already been
paid to the government by the treasury challan.
the amount which the petitioner received on account of 3% additional increment was directed to be refunded, which the petitioner has done, and now he wants a refund. This is the case.
Yes, but and Milord, there is no such grievance raised to the authority concerned by any representation or any application to that effect, Milord.
আরেকটা অর্ডার আছে
এই যে আগেকার অর্ডারটা দিলাম না, সেম অর্ডারটাই হবে, শুধু এখানে ডেট, এই রিফিক্সেশন, এই ডেটটা হবে 20th of January 2015.
This is also Jhargram.
ওটা আগেরটা বোধহয় 12 করে দিয়েছে, ওটা দেখে নেবেন। এটা কি অমিতাভ, সো ইট উইল বি হিজ, এখানে সব হার করে করা আছে, ঠিক আছে? Otherwise everything remains the same with the earlier matter. আগেরটার থেকে দেখেই কিন্তু করবেন, এর আগের মামলাটার থেকে আমি কারেকশন করে দিয়েছি।
I am for the petitioner. The matters, my lords, related to the higher scale of pay. Petitioner, my lords, before joining, my lords, he completed the part 1.
Has your prayer been considered?
No, ma'am. This is
Where is your representation?
the page, my lords, page 60.
60.
Effective service. I candid before your lordships, my lords. Your lordships order me. After Utpal Kanti Karan, my lords, I made the representation.
Will it be in terms of Utpal Kanti?
My lord.
Lordship,
I can.
I'm appealing for the state.
Yes,
I'd like to submit the instruction.
please give.
Concerned DI. Kindly have a look. Kindly have a look. It's
Another thing, my lords.
Yes.
Before, my lords, I made the representation, my lords. Earlier, I filed a 2 writ petition, my lord, which I, my lord, not press, my lord. I disclosed the writ petition, my lord.
Why did you not press?
At that time, my lord, the larger judgment was not come, my lord. I also written in the representation also, my lord.
এটা হিজ হবে, এখানে হার করা আছে,
ডিস্ট্রিক্ট ইন্সপেক্টর স্কুল পূর্ব বর্ধমান।
ঠিক আছে? ডিআই
পূর্ব বর্ধমান।
only the DI, কিছু লিখিনি কোথাকার, keep this on record. All right, disposed.
Great.
I'm for the petitioner.
I'm for statement.
TR Challan is at page 17.
Your PPO, please.
PPO is at page 18, my lord.
I have no direction as yet.
Right? Did you seek for instruction?
No, my lord.
Why not? Post.
Machu Post.
And for the state as per the district inspector of school, lordship.
What is the prayer of the petitioner?
Change of name.
Change of the school name, lordship.
After
School name?
After lordship, land has been donated by the petitioner, lordship, grandfather. That condition is there if the any lordship after the death of the father, name has been changed. So lordship, he prayer for before the district inspector of school or the board. But
board is not here.
Board not here. Board party ache kintu. Board. But lordship, DIA is no role in this matter, lordship. But
The petitioner,
West Bengal Board of
a
Secretary.
learned advocate for the petitioner, mentioned the instant matter for upgradation,
Nahin.
citing urgency. Stop. At the time of call, when the matter is taken up for consideration, comma none appears on behalf of the petitioner. Stop. The state is represented by the learned counsel. Stop. The writ petition stands dismissed for default.
Lots.
My lord, I appear for the petitioner.
Lordship, in this matter, Mr. Nirmalla Vishwas is appearing for the state. He has not come to the court due to the demise of his mother-in-law. Today is the Sadhya ceremony. So I am praying only not today on his behalf.
Not today? Tomorrow. Is there any other party apart from the state?
No, mainly state, higher pay scale matter, already decided by the larger bench.
No, I'm for the petitioner. Notice has been served.
Who is your other side?
Subhra Nag and
Yes.
Here, petitioner is working as.
Are you there for the state?
Mr. Vivekananda Bose is on behalf of the state. He's on the way.
All right.
Here,
Yes.
petitioner is working as headmaster of a higher secondary school. He initially joined in a secondary school in the year 2008. The school has been upgraded on 27th of May 2014. But prayer has been made in terms of the judgment as well as the notifications quashed. So I am praying for granting of 3% additional increment in terms of your lordship's order quoted the honorable division bench. Only one prayer, since it is a district not 24 Parganas, but he has complied with complying the judgment of Subir Kumar Ghosh, the initial judgment. If your lordship kindly take note of the judgment of the Subir Kumar Ghosh and compliance report at page, but I have annexed that also. Page 53, 52, 53. So I'm paying for that judgment. I'm handing over to your lordship, same DI. So I'm paying for same order. Only here, additional increment was stopped due to that notification. Since notification was quashed, your lordship granted 3% additional increment. Kindly see. Only change will be not stopping, it will be continuing. Already order is there.
That is the problem.
Not getting it.
এই judgment টা দেবেন
Yes.
Page.
Page 54 and 55. Subir Kumar Ghosh, same status, same DI has complied with. After contempt, 1 year.
No, you have handed over a copy of this order. This will be all right. Possibly no changes required.
No
to
changes
be
required, only adding up that judgment of the Subir Kumar Ghosh, subject to correction. This is my prayer. Because same DI has complied with in terms of the Subir Kumar Ghosh. Your Lordship quoted other
This
division bench.
is, yes, the division bench.
That is there.
And
I am paying for.
this is
Only in respect of South 24 in the second page, it will be North 24.
not 24 Parganas.
And only correction is required.
North.
Nothing.
All right. Yes, your submission, please.
Problem is, my lord, I was going to tell your lordship, on this I have no instructions with me on this.
But then the issue has been decided by the division bench.
I get it. If your ladyship is please to just give me some time, just one day.
Why? Decided issue.
এটা অর্ডারটা দেখো তুমি
আচ্ছা এটা আসুন 1 2 3
আমি দিচ্ছি তোকে রিপোর্টেড হয়েছে হ্যাঁ
3
না ছবি তুলে নি যা
4
ছবি তোমার ঘরটা পেয়েছো অলরেডি দিছি
পেজ নাম্বার
ছবিটা তুলে নেন না
learned advocate for the petitioner draws attention of the court to the refixation of pay as made by the District Inspector of Schools, Secondary Education, North 24 Parganas. In a similar matter, in compliance of the direction passed by the court in WPA 6217 of 2021, within bracket Subir Kumar Ghosh versus State of West Bengal and others.
Reported also. I have handed over.
আচ্ছা রিপোর্টেডটা রয়েছে যখন দিয়ে দিন রিপোর্টেড ইনস্ট্রাকশনস
না তুমি
ঠিক আছে
ইন্ডিকেটরটা থাকে কি এটা একটা কনফিডেন্স থাকলে খুঁজে পাওয়া যাবে সমুদ্র এটা আমার মনে
disposed.
Get here. March up. I'm for the petitioner. Here, the petitioner is paying interest on delayed payment of his postgraduate scale of pay in spite of the order passed by the Honorable Court. On page 17 is the order passed by the court in the year 2018. My lord, got it. Now kindly second page.
Yes.
Following the ratio of paragraph 5.
Yes.
12.3, that is my ROPA 98. His pay scale should have been considered and recalculated, not considered, recalculated. Refixation within such and such. It was not done. Contempt petition file. In terms of the contempt petition, page P321, it was accorded. But kindly see the date, 2025. Now payment has been made at page 27. Date of payment is 31st October 2025. There was a direction for recalculation with effect from 2000, my lord, 3, when the petitioner was entitled to get in terms of the judgment with all areas.
Now this 2003 is maintained.
Payment has been done since
from
2003. Correct.
But at a delayed point
Delayed
of time.
point, 7 years.
For which you want
I am entitled to get interest because it would have been, there is a judgment of our High Court on the division bench affirmed by the Honorable Supreme Court. And states the appeal kindly cease. From the date of accrual,
my lord, kindly appreciate, my lord, the petitioner was appointed in a past graduate category.
Don't say all these things because the issue has been decided. Only address the point of delay in making payment.
Delay payment, my lord.
Yes.
Kindly come to my report's last portion.
Report. Oh, achha.
And paragraph 5 on paragraph, there is no paragraph. It is from page 4. How it has been discussed. Because interest would have been paid from the date of accrual. Since it was not done, it is the duty of the authorities to make payment. It is in case of retirement, it is in case of arrears salary. Only difference is
He was appointed as a past graduate for physical education, my lord,
education
but after
already
court's order, he was granted
example,
postgraduate
quoting the
skill,
Supreme
my
Court
lord.
decision also.
After postgraduate skill, all area claim already paid, my lord. Now, interest claim is
And this
my humble submission, my lord.
has been
It's unjust to
upheld
the
by
state,
the
my
Honorable
lord.
Supreme Court in SLP. I have checked it up.
Please come.
This is all Sarab's order including arrear within a period of. They have not done so. Paragraph 5. It could have been paid then within 6 weeks from the date of accrual. That means 2003. My right.
Where is the order passed in contempt?
My lord, oh yes. Contempt order has been it has been disposed of. I have not. Oh no.
This is a MAT order. I can.
MAT order thereafter, my lord, appeal disposed of. It was dismissed for default. They did not take up.
Order has been complied with.
Complied with.
In the contempt, did you not pay for interest?
No, no, I cannot because it is merging with the original order.
Yes.
I cannot do this.
But then the court did not.
No.
You did not pray also.
I did not pay because of the fact my right has been
Achha,
settled by virtue of the order of the court. And that is dictum of the Honorable Division Bench.
The petitioner approached this court. Now, the petitioner is an assistant teacher of a school. Assistant teacher or
Yes,
assistant
for
teacher
physical
of this
education
school
subject, man.
stuff. Seeking a higher scale of pay, he approached the court by filing writ petition being WP 7955W of 2018, which stood disposed of by the court on 12th September 2018 by directing that the writ petitioner shall be entitled to higher scale of pay. The court directed that the benefit that the higher scale shall be accorded, including arrears, within a period of 6 weeks from the date of communication of the order. As the authority failed to act in terms of the order passed by the court, the petitioner filed an application for contempt being CPAN 1144 of 2018. During the pendency of the contempt application, the benefit of higher scale of pay was accorded. Vide Office Memorandum dated 27th August 2025 with effect from 11th of July 2003, that is the date of improving his postgraduate qualification. The payment, however, was ultimately made to the petitioner only on 3rd of December.
1st of October, page 27.
31st of October. 31st October 2025. The petitioner pays interest on account of delayed payment of his legal dues. The learned advocate, the petitioner relies on the judgment delivered by the Honorable Division Bench of this court on 3rd December 2010 in MAT, name of the parties. Learned advocate representing the state respondents has obtained instruction from the District Inspector of Schools, Secondary Education, Noida, signed on 15th of January 2026, which mentions that the claim for interest made by the petitioner cannot be accepted as there is no relevant government order in this regard. Paragraph. Fact remains that the right of the petitioner for receiving the payment was declared by the court vide order dated 12th of September 2018. The authority was to ensure that the petitioner gets the benefit of the order, including arrears, within a period of 6 weeks from the date of communication of the order. The order of the court was communicated to the DI with a communicating letter dated 17th of September 2018. The authority ought to have disbursed the dues of the petitioner within a period of 6 weeks from 17th September 2018. The benefit was, however, passed on to the petitioner only in the year 2025, 31st of October 2025. There has been enough delay in making the payment to the petitioner. In the meantime, the petitioner had to file an application for contempt and had to defend the appeal which was preferred by the state against the order passed by the learned single judge. Paragraph. The issue regarding grant of interest on account of delayed payment has been discussed in Sri Shivram Giri within bracket Supra, the court while deciding the issue placed reliance on the judgment passed by the Honorable Supreme Court in the matter of Alok Shankar Pandey versus Union of India, reported in AIR 2007, SC 1958. Wherein the Honorable Supreme Court held that equity demands that when payment is made at a delayed point of time, then the principal amount should be backed up by interest. The Honorable Division Bench was pleased to affirm the order passed by the learned single judge in awarding interest at the the fact that there is no government order for grant of interest on account of delayed payment implies that the authority always should take steps within the time specified and ought not to delay in making payment, especially when the right to receive payment has been adjudicated by the court. Step. As admittedly, comma, there has been delay in making payment to the petitioner, comma, the District Inspector of Schools, Secondary Education, Noida, is directed to grant interest on account of such delay, calculated, grant simple interest korben, calculated at the rate of 6% per annum to be paid on and from ডেটটা একটু দেখে নেবেন তো, মনে হয় 29th October হবে, 6 সপ্তাহ will be calculated from 18 সেপ্টেম্বর থেকে 6 সপ্তাহ ক্যালকুলেট করবেন, করে যেখানে যাচ্ছে 29 October 2018 till 31st of October to 30th of October 2025. Such payment shall be disbursed in favor of the petitioner positively within a period of 8 weeks from the date of communication of this order. Stop. If the interest is not paid in terms of the direction passed herein above, comma, then the petitioner would be entitled to receive 2% additional interest. That is 6 plus 2, 8% interest on and from the date, 8% interest for the aforesaid period. ঠিক আছে, read petition stands disposed.
From 18, not from 2003.
From 18.
From 18, from the date
From
of order.
18. From 6 weeks after your communication, it will start from
Since the
October.
date of order is crystallized my right, not from the 2003. All right. Let him get something also.
Yes.
Much obliged, Lordship. 19 is the same without any change of 17. Same
I
DI,
appeal for the
same
statement.
Same DI without any change of?
Order of 17, item number 17.
Not 25 organs.
Not 25 organs, same DI. Without any change, it is to be.
Acha. This is higher scale?
No, 3% additional income.
Oh, acha. Same as 17.
17. School was upgraded after he joined.
Right.
Grateful to you.
Is disposed of there.
No, affidavit of service, upgraded notice. Much obliged.
I'm for the state.
The higher scale of pay, my lord, the petitioner's representation was pending, my lord. Page 36 is there,
Same order as the other one?
my lord.
Hey, Shumanto. Which one?
Page 13.
Same as 13? What will be the change?
But DI will be changed, my lord.
DI change?
Yes, my lord. DI will be, my lord, South 24 Pargana.
South 24 Parganas.
Right, DI will consider the representation. Yes, my lord, I am for the state.
Disposed.
Hey, there. Brother.
Item number 21, I am appealing for the petitioner. Petitioner has come before your lordship paying the area of the salary, my lord. From 2011 to 2006, my lord, the petitioner joined in Khasbar High School in 1996, and since then he has been rendering his service as yet. But in the year 2011, my lord, petitioner has been suspended from his service illegally. And if your lordship kindly come at page number 15, That is the order passed by the Honorable Coordinate Bench. And if your lordship kindly come at
Yes.
the bottom of the page number 15, that no, I'm reading, my lord. No material is produced before this court to substantiate the claim of the respondent number 7 of the pendency of any disciplinary proceedings against the petitioner and purported resolution adopted in the meeting of the managing committee of the school under reference on February 9 to 2012 has also not been produced before this court. Apart from the ground of violating the provision of the provision against the petitioner, the pendency of a disciplinary proceeding has not been substantiated by the respondent number 7 before this court. In view of the above, the impugn order and the purported resolution dated 9th February 2012 allegedly adopted in the meeting of the managing committee of the above school are quashed and set aside. Thereafter, my lord, I have also been prevented from joining in the school, and challenging that inaction, I have also preferred a contempt application, and by the virtue of the order of the contempt application, I joined, and thereafter I have been continuously discharging my duty with due diligence. As yet, I am standing at the verge of my retirement. I will be retired on 28th of this February, my lord. My lord, I have repeatedly made a written representation before the concerned authority to realize my area of the salary along with the consequential benefit, and presently, my lord, I am entitled to get 32 lakhs something in the name of the
Period of due.
Period of due, my lord, 2011 to 2020.
Give me the dates.
Yes. Your lordship, kindly come at page number 41. That is my last representation that reflects everything.
Who's for the state?
For the board, my lord. It has been
Did
served.
you intimate?
Yes, it has been
Who
served.
is the learned counsel appearing?
Well, so far my information is concerned, Sushobhan Sengupta and Tapun Kumar Roy are appearing for this state.
All right. Page 41,
Yes.
DI of schools. This has been forwarded by the school.
Yes.
You are the headmaster?
Yes, my lord, I am the headmaster.
Period 2000 9 to 18.
Yes.
20 years service benefit.
20 years service
Period 2011 to 12, March 12. Has your pension paper been made ready?
Well, state can reply, Your Lordship.
Not yet, my lord.
Your pension paper is not ready. Why are you approaching this court at such delayed point of time? If you had your arrears from 2009, 11, 12, and you'll be retiring the day after tomorrow, and you are coming now. Why?
Yes, my lord, there is a delay, my lord, on the part
How
of
will
the
you
petition.
explain the delay? Or is this delay deliberate?
No, my lord, not at all deliberate, my lord.
Not deliberate.
Not.
Why have you? How could you survive?
Yes.
What yes? Please come. The petitioner is serving as the headmaster of a high school. Stop. He is due to retire on attaining his normal age of superannuation on 28th of February 2026. Stop. He alleges that a certain amount is due and payable to him on account of arrears salary, comma, 20 years service benefit, increment on acting as the headmaster of this school, totaling to rupees 32,79,531. Stop. Page number 40, please come. There is a communication from the DI.
Yes, my lord. As in compliance with such communication, my lord, petitioner time and again approached the concerned authority, submitted but not, they do not return the received memo. Thereafter, my lord, petitioner has.
You are the headmaster of the school.
Yes, my lord.
And you do not know how to get things received by the DI.
I am submitting before your lordship upon instruction whatever has been done with the
The
petitioner.
client is not giving you proper instruction. Rest assured. He deliberately waited for this time.
What happened, my lord, actually during that period, my lord, he has been repeatedly running from pillar to the post for obtaining this area of salary, my lord. And that is why the petitioner submitted all the written representation. If your lordship kindly comment, the first written representation which has been submitted in 2020.
This writ petition has been filed on 3rd of January 26.
Yes, my lord. Yes.
Right?
Yes.
I can understand that he has acted with malafide intention.
Bow down, my lord.
The petitioner কি বললাম শেষটা? Such and such. From the documents annexed to the writ petition, it appears that there is a communicating memo from the District Inspector of Schools, SE Paschim Mednipur, dated 7th June 2023, requiring the petitioner to submit necessary documents for payment of his arrear bills. Stop. There is nothing on record to suggest that the petitioner acted in terms of the request made by the DI. Stop. There is, however, a representation dated 2nd December 2025 by the petitioner, received by the office of the DI on 9th December 2025, requesting releasing payment. Stop. It is not clear as to whether the supporting documents of the claim have been forwarded by the petitioner to the DI. Stop paragraph. As it appears that none represents the state respondents despite service, affidavit of service, and the notice affidavit of service filed in court is taken on record. Stop. Next. As it appears that notice of upgradation given?
Yes, my lord.
Take it on record, please. As it appears that the representation of the petitioner seeking releasing area dues is pending consideration at the end of the DI, accordingly, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Paschim Mednipur, to consider the petitioner's prayer for releasing his area dues strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The petitioner shall be obliged to submit all supporting documents respect of his claim. Stop. If the claim of the petitioner is accepted, then necessary consequential steps shall be taken by the DI without any further delay. Stop. A reasoned order shall be passed and communicated to the petitioner. Disposed.
This is also interest on arrears salary. Only date will be changed. Will kindly take the dates. Order at page 20. Similar as item 8.
I'm for the state led by Mr. Rahul Kumar Singh.
Same as 18.
Same as 18. Only date of the order and compliance and payment will be changed. Page 20. Similar to item 18. Page 20, the order passed by the court. Honorable court, Justice Talukdar, as his lordship then was. Date of order is 28th of June 2016. There was a same mandate. ADI is directed to recalculate with effect from 10 January in terms of the order of the earlier court, honorable court, within 6 weeks, page 24. It was communicated on page 27th of July 2026 at page 26. DI has received ADI. Now, let kindly take page 28. Even in a contempt proceeding after 7 years, DI did not comply in making payment. Page 28. The observation of the honorable court in contempt proceeding. Page 28. Only fact narrated, not effective compliance. But on the threat of contempt, it was paid after passing the order at page 48, 15th of May 2025.
Page?
Page 48. This is e-challan by the government, Treasury Office challan, it has paid, and page 15th of May 2025. Top box, right hand side. So this part is same as item 18.
Alright. একটু বলে দেবেন তো আইটেম 18 এর মতন হবে। সুমন্তকে বলতে পারেন বা আপনিও করতে পারেন। ডেটস গুলো একটু চেঞ্জ হবে। এখান থেকে আমি দেখে দেখে করতে হবে। ঠিক আছে? ডিসপোজড।
Grateful to you. Much obliged. হ্যাঁ দিয়ে দিচ্ছি।
Well, I am for the petition, my lord. In this case, my lord, the petition's prayer was rejected of the higher scale of pay on the ground of want of prior permit.
So the rejection.
Page 63, my lord. The want of prior permission, my lord.
Is this under challenge?
Yes, my lord.
63.
Yes, my 63. Your lordship decided the issue, my lord. Your lordship also passed an order, my lord, at page 80, my lord. Your lordship passed an order, my lord. I have taken the permission from the managing committee, and the managing committee duly forwarded it to the DI, my lord.
Please come. The order of the District Inspector of Schools, Secondary Education, Nodia, dated 15th December 2025, rejecting the petitioner's prayer for sanction of higher scale of pay due to enhancement of his academic qualification is impugned in the instant writ petition. Stop. Paragraph.
Lordship.
The issue has to be decided upon exchange of affidavits. Stop. Let affidavit in opposition be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Do you have a copy of this? You have another copy? I will keep this on record. I will keep this on record. You prepare affidavit in opposition and circulate within 4 weeks. All right. Affidavit in opposition has to be prepared and circulated within 4 weeks.
Lordship, then
Yes.
it can be considered in the
What considered?
your judgment. Your lordship.
No, it has been rejected. No scope for consideration. Now a mandatory order has to be there.
Your lordship.
This order has to be set aside. You file your opposition. If you want to take help from any other learned counsel, then please take help. All right. Keep this on record.
I am for the state response.
My lord, I am for the petition.
Yes.
It has lapsed by the efflux of time. There was no interim order.
Right. Learned advocate for the petitioner submits upon instruction that the writ petition, that the cause of action for filing the instant writ petition does not survive any longer due to efflux of time. Stop. In view of the aforesaid submission, the writ petition stands dismissed as infructuous. Stop. The anything more to be recorded?
My lord, only one thing, my client retired.
The respondent number, be it recorded that the respondent number 8 has retired from service
On attaining the age of superannuation
on
30th of January.
attaining the normal age of superannuation on 31st of January 2026. Stop.
And my lord, one thing, my lord, prior to that, school authority submitted all the pension paper, and due to
Pendency of the writ petition.
return, action was not taken.
The service benefits of the respondent number 8 shall be disbursed without any further delay.
Time, my lord, only.
At the earliest, but positively within a period of 12 weeks from the date of communication of this order. Will it be possible within 12 weeks? The entire PPO file
My lord, already
forwarded?
papers were submitted.
All submitted?
Due to pendency.
All right, 12 weeks. All right?
Yes, ma'am. Get full.
Can? What is a can?
No. Can already been disposed of, my lord.
Disposed?
May I hand up a copy of the order?
No.
Answer, my lord.
Can I take 2305 1998 disposed of? Disposed of.
My lord, on submission of the paper by the school authority, because my lord, upon
It has been submitted, he says.
The school submitted the paper to the DI, and thereafter DI sent back the paper as for want of the
objects.
Have you followed? Because of the pendency,
followed,
this
my
has
lord,
happened.
His interest. That is why I requested Mr. Hallar to say something.
Acha, likhe din to, the school is directed
Yes.
to render all necessary cooperation and assistance so that the private respondent may receive her terminal dues within the time limit as stipulated herein above. All right. Yes, next.
Item number 25, Lord, it is a matter of 2011 writ petition, 2017 Lord applications. Two fan applications are there. Matter appeared before your lordship. My lord was pleased to direct them to submit notice, my lord. My lord, I was unable to accept the notice because no application and writ petition, nothing is with me, my lord. At that time, I appeared along with my learned senior. Learned senior is no more, my lord. Kindly give them direction to submit all the copies, my lord. And so that I
What
will
is the matter about?
Your lordship, Mr. Salahuddin appeared on behalf of the petitioner, your lordship. He is illness, your lordship. Therefore, I am paying for adjournment.
Praying for?
Adjournment, your lordship. He went to check up, your lord.
Adjournment for a day?
Yes.
Only one day?
1 day.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned advocate representing the state respondent submits that she does not have a copy of the documents in respect of the instant writ petition. Stop. Writ petition and the connected application. Stop. Paragraph. Learned advocate for the petitioner is directed to serve a copy of all documents in respect of the instant matter to the learned advocate representing the state respondents within a week. Stop. The matter is made returnable on 16th March 2026. Make it 23rd March. Learned advocate representing the state respondent shall come ready with all necessary instruction on the urgent date.
One more humble prayer, but though I do not have the original brief, my lord, my assignment is not there, my lord.
Then how are you appearing if your assignment is not there?
I have confirmed with the department mass education. I was engaged in that matter at that
That
time.
you talk to your client and get it settled.
My lord.
26 as a last chance, 1 week accommodation, because I am not able to contact with my client. Old matter, one more week.
Let it be dismissed. Your client will automatically
One
come.
more week, then your lordship dismiss default, other week.
What was the matter about?
Also, brief was not also search out. So, old matter, I am not search out the brief and not contact with the client. One more week, only one more week.
Nothing remains in the writ petition. Please come. The instant writ petition was filed in the year 2012. Seeking a restraint order against the respondents not to issue the appointment letter in favor of the private respondent. Stop. A considerable period of time has elapsed. Stop. Leave was granted to the petitioner to file supplementary affidavit in August 2012. Stop. The same has not been filed till date. Stop. Paragraph. It appears that the cause of action for filing the instant writ petition does not survive at such a delayed point of time. Stop. Next. In view of the above, the instant writ petition stands dismissed as being infructuous.
May I please?
Where is your answering respondent?
My lord, answering respondents are here, my lord.
Well, they are here, the medical council committee, there's answering respondent.
Yes.
My lord, they are just outside, I think.
All right.
Yeah.
Let them come.
No, they are here, they are here. They are here.
What is the matter?
My lord, the petitioner appeared in PG, NEET PG, qualified, my lord.
Page
When
19.
at the counseling stage, my lord, they
Page 19.
respondents has a
Page
problem
19. Order the purpose.
the caste certificate.
Page
My lord,
19.
kindly comes to page 19, my.
19. Order the.
Kindly comes to page 19.
Page
19.
19.
Once there was a
এখানে direction গুলো এখানে
litigation,
ছিল, এই
my lord.
direction গুলো ছিল।
My lord, this is the order, my lord. Where, my lord, their rejection was quashed. May I read paragraph number 3, my lord?
1 minute. Yes.
Yes, my lord, kindly comes to page 21, my lord. After this order, my lord, kindly sees page 21, my lord. The West Bengal Medical Council has given me a document verification certificate, my lord. My lord, issued on self-same day on 30th January, my lord. My lord, thereafter I filled up the form, my lord. Kindly sees, my lord, my name, my lord, I'm studying the page, my lord. Page 126, my lord.
This page 22 onwards is
the all the candidates whose name appeared after, my lord, verification of documents.
Why did you annex the entire lot?
My lord,
Will it be required?
no, my lord.
Then
Only page 122, my lord. It became cumbersome, but I thought it, my lord. 126, my lord, comes to page 126. 126. That one.
Station a candidate.
No, my lord, kindly, my lord. 65, my lord, kindly 65, my lord. I beg your pardon. 65, my lord. This is the provisional list of candidates eligible for choosing, filling up for round 3, my lord, which was issued on 7th February 26, my lord. Page 65, my lord.
Where is your name?
My lord, kindly comes, my lord, 65 second name, my lord, Suparna Mali.
Right.
Suparna Mali, my lord. My lord, kindly comes to thereafter, my lord, page 126. My lord, kindly sees also my rank, my lord. In page 65, my lord, 1,37,334. This is my all India rank. My lord, kindly comes to page 126.
One 126.
126, my lord.
Yes.
One 126 Kuntal. One 126, 199. এটা কোনটা? এটা পেয়েছে 24 এটা নাম তাহলে পেজটা খোলো, ওই পেজটা দেখো, কি ভাই এটা তো সেকেন্ড বান্ডিলে 127 থেকে my lord kindly comes to page 199 199 my lord I beg your pardon my lord 199 my lord কেন
All unnecessary documents you have annexed.
My lord,
Chart and everything.
kindly my lord
What is
these
the
are
use?
all printouts from the same place my lord I could not my lord
You could have annexed the required page that is.
fish out the thing my lord this is a whole documents available in the website my lord
So what does it mean? You will
Mhm.
annex the encyclopedia over here.
My lord kindly comes in 196 my lord page 196
196.
kindly comes to from the top 1 2 3 4 5 6 kindly
196.
190
Provisional seat allotment.
provisional seat allotment kindly comes to 6 column number 6 from the top
Column number 6 from the top.
my lord kindly sees the rank is
Yes.
150460
Yes.
my lord subject choice my lord choice number is given next 144
Hmm.
my lord kindly see eye care institute of medical science and research Holdia ophthalmology my lord seat given my lord my rank is 1 lakh 1,37,343 my lord.
Now page 119.
My lord kindly comes to page 199 same inferior rank my lord placement given ophthalmology my lord after this my lord this ends at 7th my lord my lord now there is a stray list my lord again I have filled up form for stray list my lord I don't get I issued a demand justice demand justice টা কত পেজে 213 kindly my lord comes to 209 my lord page 200
1 minute. This is the provisional seat allotment and the All India rank is there.
yes my lord
Yours is 13,000.
30,000
Ideally,
15,000 got rank my lord
1 minute. Where should you ideally be? In page number, yours is 13,007. That means 190.
no, I am 1,37,000 1,50,000 is getting my lord seat placement I am not
35.
getting placement
All right, 191 I can see. First row.
190
191 I can see.
190
135. 135, then 136, 137, 3. From the bottom, the second is 1,37,400 something. You are prior to that.
prior to that
This is allotment. This is UR. Unreserved.
this is unreserved no, unreserved
So you come to the next one is page 192, 1,38,000.
192
College
kindly
of
comes to
Medicine.
page 196 my lord it's 1,50,460
Why are you going to 150 when 1,38,000 is there?
that is there my lord there my lord but I have chosen these institutions in my list that's why I
you've
have marked this
chosen those eye care institute.
yes my lord I will not get in a government college I choose private colleges my lord
All right.
they are also my lord in my choices my lord will my choices
Ophthalmology.
fill up choices ওই choice এর ইয়েটা বার করো।
Course you are required to choose on your own.
yes
All right.
yes
And
my
you
lord comes to page 213 my lord kindly my lord that will show what I have chosen what institute I have chosen
All right. You chose ophthalmology.
ophthalmology my lord if I get I will choose I have chosen pediatric also my lord inferior rank than me got pediatric my lord in an institute my lord in stray round my lord round after this is third round my lord there is a stray round subsequent to this
And what is the last rank of the candidate?
last
Page
rank of the
207.
candidate my lord will get from the last pages of the
208.
list is
1,89,000.
1,89,000
So your cases, even with the rank of 1,37,000, you didn't get a chance, whereas 1 lakh.
No, my lord, there is a subsequent case also. My lord, so once comes to page 213, my lord.
213. Yes.
My lord, kindly see this is online stray vacancy round, my lord. This is the subsequent round to the third round, my lord.
Hmm.
Kindly comes, my lord. This is my fill up choices, my lord. Kindly sees one Gauri Devi Institute, my lord.
Hmm.
Medical. This is
So
choice number
many
1.
institutes you have agreed. So many institutes.
Yes, I can fill up as many as institutes, my lord. There are preference, my lord.
All right, preference.
Preference.
Obstetrics, gynecology, and then pediatrics, anesthesia, anything that is
Anything. I can choose if I get under my category, my lord.
Hmm.
Kindly comes to my lord. এখান থেকে বার করো এগুলো পেজ 200 my lord, kindly comes to page 307. Kindly comes to the first online stray vacancy, my lord. Page 307, my lord.
Yes.
Kindly comes very fast entry, my lord. Kindly see the rank 137423. My lord, subject choice is 6th, my lord. Where was my subject choice was my institution choice was 2.
All right.
343. My lord, kindly see this is pediatric IQ City Medical College, Durgapur.
Hmm.
I would have my lord selected pediatric. Would have got. My lord, my rank is lower, my lord. My preference is higher, my lord, than this 6. I have second choice.
All right, let me hear. Where is the last date and everything that you mentioned?
Last date, my lord.
342.
342. Today is the date.
For admission. Then tomorrow and day after tomorrow is also there.
2 days are also there.
Oh, my lord.
Whatever is not allotted today,
will be
stand over till tomorrow.
My lord, kindly sees
allotted tomorrow, we stand over till
sees, my lord, kindly sees 10, my lord. My lord, page 343.
10.
My lord, kindly see 10. The reporting and admission of allotted candidates to the allotted institute for all private medical colleges. The admission process will be kindly next column 24th from 2 p.m. because 24th, my lord, at 1:30 the result was published. My lord, and up to 5 and 25th from 10 a.m. to 5 p.m. my lord.
All right. The only issue that I can understand is that somebody lower in rank has been given a choice, and
really not the case, my lord.
all right.
Case
What is
my lord,
the case?
somewhat different. My lord, the petitioner is claiming as a SC candidate. The SC certificate is not issued in West Bengal, it is issued in Delhi. Now, my lord, kindly comes to page 19, that is the order in the earlier round. 2141, my learned friend must have placed it, my lord.
Yes.
The petitioner was permitted. My lord, kindly see page 20.
Yes.
6 and 7. The petitioner is directed to immediately approach the respondent number 2 at the SSKM hospital and submit all documents along with the caste certificate to enable the respondent number 2 take an immediate decision by today. The petitioner will be permitted to participate in the counseling round, which commences on 2nd February as a scheduled caste candidate subject to verification of our caste certificate by the respondent number 2. Now, my lord, when the petitioner is applying, kindly take page 21.
Regulation.
That is the verification certificate dated 30th January. Now, my lord, your lordship will kindly consider the computer software cannot read a high court order. The choice filling that he is doing there, kindly sees under the category candidate other details. That is the third heading. Rank details, subcategory list. Yes. Category certificate issued in the state of West Bengal.
No.
So the server has taken him to be certificate not issued in West Bengal. Now, my lord, kindly sees, my lord, my notice come information bulletin.
High court order. No, high court.
এটা পেজ 213 তো পেজ 213
রেগুলেশনটা বার করো রেগুলেশনটা বার করো রেগুলেশনটা নিয়ে এসেছি
213 টা বার করো 213
Well, kindly takes my lord, second page, first line.
Second page.
The caste certificate issued in the state of West Bengal will only be considered for allotment of reserved category SC, ST, OBC category A, category B, EWS seat of state quota. Therefore, the moment he gives no there, he is not being treated as a SC candidate at all. And the first page top, your lordship will find that this is applicable for MD also within the bracket. So it is applicable for MD also. Therefore, my lord, when the petitioner is applying, the petitioner's application is being treated as a general. This he is pointing, my lord, this because of the writ petition, my lord. Now, my lord, we find out that this is the issue which has happened, my lord. Throughout, my lord, the server has taken him as a general candidate.
Now, can anything be
Yes.
done?
Now, my lord, your lordship has found that in the choice filling, that is 213, IQ city is number 2 in his choice. Now, my lord, that is the in his choice, my lord, that is only where a seat is vacant. That is OBC A seat. My lord, this we have obtained, my lord. Only one seat is vacant in IQ city, but that is a OBC A.
Anywhere else where the petitioner can be accommodated considering her rank
Lord,
and her choice?
no, my lord, this according to her choice, which we can see at 213, but that is the only place where one seat is vacant. That is last choice filling by the candidate.
213.
But I have a separate copy, my lord. Same document. Your lordship may take a separate copy, my lord. With 213. Printed at locked at 20:20 p.m. Same thing. Same thing. 20:20 p.m.
Yes.
My lord, in this list, wherever he has filled up the last choice, my lord, IQ city has one seat vacant. The same.
Pediatric.
Pediatric.
My lord, if that
So, my lord, this is a OBC A seat. But I can suggest this without, because there's nothing adversarial in this. Your lordships may direct two things, my lord. Either, my lord, to put the petitioner, give the petitioner admission provisionally in that seat and liberty to the or a direction upon the state to apply for conversion of OBC A to SC. Remaining whatever will follow in law, my lord, another OBC A seat to be given from somewhere else. But that will follow, but that it has to be done by the backward classes directorate, which is not a party here. Anyway, that is not an issue. Anyone can be added. But the other thing, my lord, your lordship, without disturbing the reservation or the roster position, as far as the petitioner is concerned, in view of these facts and circumstances, earlier round of litigation may direct the state to create a supernumerary post vacancy for the petitioner only, which will die with the petitioner's course being finished. Then the no vacancy position is to be disturbed. No one has to apply, etc. And there are some peculiar facts in this because the earlier round is there. It was directed.
It was only because of the earlier round of litigation that the petitioner gets a chance over here, right? And she has filled in so many names of the institutes. Nowhere she can be
But
accommodated.
your lordship will consider this is stray round after stray round.
All seats have been filled up by now.
All seats have been filled up by now.
But then if her rank is considered, and she is in a far better position than many others who have been accommodated.
Maybe, but in a situation where she was being treated as a
general.
domicile candidate. But since she is saying no there, she is being pitted against the all India. There are 50-50 ratio.
No,
50 for all India, 50 for state quota.
She cannot be pitted against all India rank. She has done her MBBS from West Bengal, my lord. Cannot be, my lord.
The creation of supernumerary posts, there are a lot of issues with that. But then at the same time, this vacancy which is available is reserved for an OBC
A candidate.
A candidate.
But unallotted. Unallotted.
As of now, it is vacant. Yes. That is the reason you say that it can be offered to her. Otherwise, it could not have been.
Tomorrow, 5 p.m. if no one comes, this will go vacant. In any event, it will go vacant.
Please come.
As much as I can unburden Mr. Dotto.
Yes, yes. Look at these pages. This is burdening not only y'all, the court also.
My lord, it is burdening to me also, my lord.
My lord, nothing
Kindly, my
after
lord,
page 21 was required.
My lord, kindly understand my predicament also. My lord, I am putting some papers before court of law. If a branch comes out in a printout, my lord, how can I
Curtail
segregate
that, yes.
segregate papers from that?
এটা কোন পাতা বল?
Um,
But I have a separate copy of page 21 also, if your lordship wishes.
Wait, please wait. Let me see if I require, I'll call it. And, the immediate urgency for consideration of the writ petition is the revised, is the tentative revised schedule for WB NEET PG Medical within bracket MD bracket close state quota, private management quota and NRI quota seats 2025 being published by the Department of Health and Family Welfare on 10th of February 2026, where the date for reporting and admission of allotted candidates to the allotted institute ends today at 5 p.m. Stop paragraph. The petitioner qualified in NET PG and her rank is 137343. All India rank is such and such. Top. She claims benefit of reservation within bracket SC. Stop. Her allegation is candidates lower in rank have been allotted seats, whereas seat has not been allotted in favor of the petitioner. Stop. The petitioner refers to the order passed in the writ petition filed by her, being WPA 2141 of 2026. Order bolam to dated 30th January 2026. Wherein the court permitted the petitioner to participate in the counseling process as a scheduled caste category candidate, subject to verification of her caste certificate. Stop. As the petitioner filled up her application form by disclosing that the category certificate was not issued in the state of West Bengal, the application of the petitioner was all along considered in the general category. Stop, na comma diye, for which the benefit of reservation was inadvertently not provided to the petitioner. Stop. Paragraph. The process of counseling started a couple of days back, and at this stage, the online stray counseling is also over. Stop. The petitioner submits that she had given her options and choices of the subjects and institutes, and she may be accommodated in any of the vacancies that is available. Stop. learned advocate representing the medical council submit
Counseling committee, medical
Uh,
counseling committee.
medical counseling committee submits upon instruction that as the computer read the application of the petitioner as a general category candidate, comma, she could not get the benefit of reservation as per her ranking. Stuff. It has been submitted that after the stray round of counseling, comma, the only vacancy that is available is in IQ City Medical College, Durgapur, in MS Ophthalmology. But see, this is what he says, it is ophthalmology.
I have applied for pediatric there, my lord. Their department is known for pediatric, my lord, not for ophthalmology, my lord.
Known for, I do not know, known for or not.
My lord, my kindly sees, my lord, my selection, my lord, it was for pediatric.
But if there is no vacancy in pediatric over there, then what can be done?
Somebody else with lower rank than me has been allotted that seat, my lord.
Now the allotment is over. The candidate has to move out. Then you have to add that candidate as party because that person will be adversely affected.
My lord, let me add if they communicate who is
Then then your eye care may not be there.
my lord, kindly, says my lord, ophthalmology.
Speak to your client. You don't take decisions in that manner.
He is not averse to ophthalmology.
Also,
I am not averse to
eye
ophthalmology.
care, he has given ophthalmology.
No, submission is if the ophthalmology place where she chose is given to her, she'll be okay.
But in IQ City, she has chosen anesthesiology also. At
My
page
lord, that is
230.
fine, my lord. That is, my lord, kindly, my lord, I have to fill up this form, my lord. I have to fill up this form. There are couple of 20 odd, 22 odd seats over there. I have
Speak to your client
my lord,
if she is okay with
pediatric. He needs pediatrics, my lord.
there is no question of needing.
My lord, this is my lord. My humble submission is a blatant. My lord, kindly comes to that page, my lord, where my learned friend shows, my lord, that
I can see page 303, IQ City MD Pediatrics, and the candidate is SC.
yes,
Page 307.
my lord, and kindly comes to also page 21, where my learned friend is showing that the system does not know. This is clearly written that caste certificate accepted on the basis of court order, my lord.
Right, but the system can't read the court order. It is
Page 307C.
Yes.
IQ City.
IQ
This
City.
is what you showed. IQ City College Medical Durgapur. This is MD Pediatrics.
MD pediatrics.
And it is SC category candidate. How do you say it is reserved for OBC A category?
No, OBCA is ophthalmology, man.
In IQ City, there are other.
Those are filled, man. All other seats are filled. This OBCA ophthalmology is empty.
Now,
Can 1 minute? The court is trying to work out a solution, and Mr. Bandyopadhyay is cooperating. You see, then is there pediatrics or something?
But what I can suggest is, Malad, as my learned friend rightly points out, that tomorrow nothing is in the schedule. Nothing is
Nothing is there. You
But let
work
us
it out.
I'll try to take instruction from my client.
Right.
If anywhere else it can
Else-
be put. Your lordship will only then pass an order to the extent that since I am to take instructions,
all right.
the admission will not be treated as closed as far as the petitioner is concerned.
That is all right. আচ্ছা কি বললাম? Stray round of
আজকে তো ফাইনাল পেয়েই যাবো আমরা কি আছে না আছে
ophthalmology and not and but the seat is reserved for OBC A category candidate. Stop. The no the as per the preference given by the petitioner, comma, she would like to go for pediatrics in the said medical college. But if other options are available in other colleges, then
My lord,
Ma'am, I have to.
please speak to please speak to her.
But in page 8 also she has said about ophthalmology.
my lord, what she is saying, she has to practice that for her whole life, my lord.
Obviously.
She needs pediatrics, and when she is getting pediatrics in her rank, and she's done her MBBS
So
from.
she is not getting in her rank. That she needs to understand. She has made a mistake while filling up the form.
No.
Nowhere this complaint has been made.
No complaint has been made.
No, but
Much
there's no
later.
use going to that because the
Right.
court has directed her to be treated as an SC candidate and you have to act accordingly. Now, acha, paragraph din to. It as the learned advocate representing the committee, na ki bollam ekta, counseling committee, seeks to revert with instruction as to where the petitioner can be accommodated, considering her All India ranking, comma, release the matter for further consideration tomorrow. At 2 p.m. do I keep it so that you get a little bit more time?
2 p.m.
ঠিক আছে?
কালকে করে দিস।
Take this back. I do not need it.
On indulgence, my lord, affidavit of service I will file tomorrow.
No issues. If your learned friend is there, what is the use? No use.
NMC, NMC.
এগুলো লাগছে না, ফেরত দিয়ে দিন।
Captain.
But please, Your Lordship. Mana for the petition. As you kindly sees, my lord, this application for transfer has been pending before the School Service Commission. So on the earlier occasion, my lord, my learned seniors, my lord, has filed a report, which my lord showed that my rank in one of the schools was number 1. So since my school, I was in number 1 in that particular school, but even in spite of that, they could not give me the recommendation for transfer because of the suspension of the portal. This is what, my lord, they said in the report.
R.N. Roy Girls College
Yes,
vacancy is still available?
No, it is not.
Not. Where has the vacancy gone? SLST?
That clarification I have not received.
Then
but
where
we
can you?
inquired from this HM of the school,
Yes.
and they have intimated us that there is no vacancies in Sanskrit or at any level.
So, my lord, at least I maybe, my lord, as pursuant to the rule.
You make further application and because
But,
right now the vacancy is not there.
That, my lord, is not the rule. If I just could take your lordship to the rule once, in this kind of cases, my lord, what would be the situation? My lord, could I just take your lordship, my lord, to my lord, page number 35 of my writ petition?
Yes.
So, my lord, there your lordship will see, my lord, the amendment. It starts
This is a transfer on what ground?
on the ground of medical ground.
Medical
On
ground?
her own medical.
Medical ground?
Yes.
All right. Self-medical.
Yes, self-medical. 35, my lord, it starts.
Hmm.
Kindly sees, my lord, page number 37 once.
Yes.
So there your lordship will see 4, may I please, my lord? Central Commission, upon receipt of the application for transfer from the District Inspector of Schools, shall consider the same only against the vacancy available at the time of the consideration on the following basis. Kindly keeps it over, my lord, ABC. D. In case of application for transfer in the category of rule 4A to D. So, my lord, I am 4A. By a teacher of a particular subject to a school which is already having sufficient or excess teacher in that subject, Central Commission shall not consider the application for transfer to the opted school. In the event when option exercised are not found suitable, the incumbent may be considered for transfer to a school having requirement of the subject teacher nearby to the opted school. So my lord, now keeping this particular provision in mind, this honorable court, the honorable coordinate benches on number of times where my lord senior was there for the commission, my lord has my lord given a personal hearing to the of the petitioner, my lord, with the chairman of the school service commission
A school
to
which
find
is
out the
close
school.
to
That's it.
your opted
That is
school.
it. So, and my second limb of my submission to your lordship, that the rule, if I just could take your lordship to page number 40, I'm not sure if it is legible. I don't know, page number, because page number 40, my lord, is the another notice, my lord, which says that what particular time should be my lord, required for the purpose of consideration of the application by what kind of authority. So my lord, page number 41, my lord, there the school service commission should dispose of the or issue recommendation or reject at page number 41, first column and first row, within 1 week from the date of receipt of the transfer case from the DI. So they were supposed to take care of this within 1 week from the date of receiving that from the DI, which they
Is it one?
One.
No.
Oh, I'm so sorry, it is 3 weeks. Within 3 weeks from the receipt of the transfer case from the DI. I'm so sorry, man. So 3 weeks was over by long back. They did not do that within the 3 weeks. So now they are just trying to take the benefit of their own wrong. So I just beseech your lordship, my lord, since I have been medically examined, everything has been done. It is the rule which says that my case could be considered in an alternative places. This honorable court on earlier occasions also.
Two things. Firstly, wrong has been done. It is a huge system. There is a guideline for the time, but we are dealing the entire state. DI is looking only at his district. School is only looking at the 10 teachers in the school. But I have to deal with the entire bulk. So no wrong has really been done. The situation of the petitioner is unique. This rule does not cover the case of the petitioner in a strict sense. Here you had reached the position, all that was left to be done was the submit button was to be pressed and your recommendation would have been generated. It is not a case that you could not join because of whatever reason is stated here. That by a teacher of a particular subject to a school which is already having sufficient or excess teachers.
Anyway, if an opportunity of hearing can be given and the teacher can be can find out, can
This was an application of 2022.
Yes.
In the meantime, what is the health condition of the teacher, whether it has improved, whether it has deteriorated? That is why I was insisting that let a fresh application come, let him have the benefit of going through.
That means he has to pass through all the steps all over again.
Because since he was not recommended at that point of time,
Because of the suspension of the portal,
yes,
the
yes.
petitioner was not at
Some
fault.
point the portal has to stop, or else we cannot do the recruitments. If we are constantly transferring, our vacancies are getting shuffled, then we cannot do a recruitment. So that
Why can you not do the recruitment?
because our vacancies will change.
Yes.
If I have to declare the vacancies, I have
The
to
tentative vacancy list is being published, and then only thereafter that the final vacancy list comes out after you post these candidates in the transferred schools.
start. It
No,
starts
it doesn't
with
matter.
schools giving us the
Please
vacancies.
come. Learned advocate representing the commissioner, a commission submits that the vacancy in the school where the petitioner's rank was 1 in the year 2022 is no longer available. Stop paragraph. As the petitioner seeks transfer on medical ground and crossed all the hurdle to reach rank 1 in one of her opted schools. But the recommendation could not be made because of suspension of the portal. Accordingly, the court thinks it fit to direct the secretary of the commission to grant an opportunity of hearing to the petitioner. So that she can be recommended to a school which is close to her opted school. Stop. The hearing shall be provided within a period of 4 weeks, and if any school is available for transfer of the petitioner, then necessary recommendation shall be made without any further delay. The writ petition stands disposed of.
Grateful. But they should not take this point of suspension.
That is gone.
This is the court's order.
This is the point they.
আচ্ছা একটু লিখেই নিন সাসপেনশন অফ উচ্চশ্রী পোর্টাল যেটা আছে
That is specified. It will be.
at the earliest. I have not given that time, but within 4 weeks give him an opportunity of hearing.
That will be.
Find out and then
Grateful.
place the petitioner.
Grateful. 28, I am for the state. As per lordship direction, I filed the report.
Why did you not submit your name on the last occasion? I see your name was not recorded. If you feel without your name you'll get your remuneration, then that is fine.
I will kindly allow I supply the name.
Yes.
On the last occasion, lordship further directed to submit the report. What is step taken by the year? Kindly see the page 2, my lord.
Good.
Sub paragraph 2. Two documents is required for compliance of the court's order, my lord.
What 2 documents?
One document.
Did you give a copy to your learned friend?
Yeah,
Give.
I have seen that.
You've seen
I
what
have
is it?
seen that. Your lordship kindly.
Document you want?
One is, my lord, income
Page,
certificate of the
page 18, 18. Page 18 of the report. No, no, এই রিপোর্টটাই চেয়েছি।
Family income certificate issued by the concerned BDO at the material point of time. What is the material point of time?
And I am told, my lord, the school has already, in terms of this letter, school has already sent to the, my lord, the
DI.
DI.
Already forwarded?
But yesterday, my lord, I have instructions, my lord.
All right.
I don't know, my learned friend, Paras.
Family income?
Such instructions.
A declaration certificate issued by a competent authority from the petitioner is dependent or not on the earning of his father at the time of his death. Did you get the declaration certificate also?
Yes. I am just now, my lord, I have over telephone. I talk, my lord, that these documents school has, my lord, collected from the
ঠিক
PTO
আছে।
and my lord,
A report filed on behalf of the Joint Secretary within brackets Secondary Branch, School Education Department. In court today is taken on record. Stop. Let a copy of the same be handed over to the learned advocate for the petitioner. Stop. It appears that the DI, video communicating letter dated 17th of February 2026, sought for certain documents from the head of the institution. Stop. According to the petitioner, the said documents were already forwarded, not were, have been forwarded to the DI. Stop paragraph. Release the matter for further consideration on 18th of March 2026. Stop. An updated report from the District Inspector of Schools shall be placed before this court on the adjourned date.
Grateful one.
Acha, একটা line. Be it recorded that Hutchinson learned advocate appeared on behalf of the state on 7th January 2026. Stop. His name could not be recorded. Was inadvertently not recorded.
Grateful.
18 March. DI record. Grateful to you.
I am for the petitioner in this matter.
the petitioner was appointed as headmaster in a higher secondary school in the year.
Who's for the state? You for the state, you are for
I'm
the?
for the teacher in charge, my lord.
Yes.
আমাকে বলতে দেন petitioner was appointed as headmaster in a higher secondary school on the recommendation of a school service commission. And my lord kindly come to state review the page 24, my lord, of my writ petition. The approval of my appointment of the petitioner as headmaster in a higher secondary school. Thereafter, my lord kindly come to page 25. The pay was fixed as headmaster in the school on the date of his appointment. Again, his pay was fixed on 1/1/2020. And since then, the petitioner was working as headmaster after on the basis of the said pay fixation. And he retired on 31st.
You are the institution.
My lord, kindly see this document. All the online pension file was returned back to the school, and the DI asked the teacher in charge to recast the pay scale, my lord. My lord, kindly see, the pay scale was fixed by the DI long back in 2011, my lord. How can I recast it? Is the DI to recast the scale of pay?
Why the recast would be made in accordance with law? The headmaster was allowed 3% additional increment, which is settled, has been settled by this honorable court, and as per circular of the government. I'll kindly see once again. The DPPG made a observation after taking after taking the pension paper as forwarded by the school, DI of school SC Purva Midnapur.
What should your pay band be? According to the DI.
My lord, I said.
1 minute. According to the DI, in the year 2012, it was rupees 23,280. Is it proper?
Yes.
This is proper?
Yes, my. And thereafter, my lord, kindly see next page. 2020, my pay was fixed, 77,700, page 26. Page 26. Since 2011, I am drawing the pension.
Page 25 is 23,280.
Yes.
Yes.
Next page, it was fixed on 22 December 2011. The pay was fixed. Next page, my lord, my pay was again fixed on 1/1/2020. 77,700.
Which portion?
Last
yes,
11,
2020.
column 11.
Hmm.
And I have superannuated on 31st January 2023. My pension paper was submitted, but due to some technical defect, my pension paper was not accepted in the portal. And as such, the DI of school SC Purva Midnapur wrote a letter to the Commissioner of School Education, page, my lord, page 30. Page 30. Page 30. My lord, serial number 5, finding no other way, this office decided to prepare manual file and forwarded to the Assistant Director of Accounts Section, Education Department, Purva Midnapur for observation on ATO. Next, on ATO, the Assistant Director of Accounts, Secondary Education.
On a perusal of the report filed by the District Inspector of Schools, Secondary Education, Purva Midnapur, signed on 19th of February 2026, it appears that the DI is unable to process the pension file of the petitioner, as the same is lying at the end of the head of the institution. Stop. According to the head of the institution, there is an issue with regard to the pay fixation of the petitioner. Stop paragraph. The petitioner has annexed the I-OS-MS document to show that his revised basic pay as on 1st January 2020 is rupees 77700. Stop. The petitioner retired from service on
31st January 2023.
31st January 2023. Was any pay hike?
Yes, yes.
There was a pay hike after 2020?
Yes.
What is your last pay?
Last pay.
Where is the certificate last pay drawn?
There is, my lord, last pay drawn, my lord. It is in the pension file, not with me.
You must be having your salary statement or something to show how much was your last pay.
Yes, yes.
The head of the institution is directed to immediately submit the details of the petitioner in the login ID by taking into consideration the last pay drawn by him. Stop. In the event the head of the institution does not take steps to forward the details of the petitioner, not forward, insert the details of the petitioner in the requisite login, then serious consequences will follow. Stop. Release the matter for further consideration on.
Last pay drawn by the petitioner, that should be forwarded to the DI of school. Not as per observation of Director of
11th March 2026, 2 weeks time. In case it is not done, his salary will be stopped. You can take this back.
Late by Mr. Shami Mohammed, Lordship. Can I fix it tomorrow, Lordship?
But here, Lordship, the second time matter adjourned. Let the matter will be adjourned for the bar council election, Lord, after the bar.
No, Lordship. Last occasion, no, Lordship. Last occasion, he has submitted on the interview, on the
Let the adjourn, Lordship, after that.
virtual mode, Lordship. Lordship, can I fix tomorrow to be mentioned, Lordship?
No, to be mentioned, it's a hearing matter. Accommodation has been sought for on behalf of the learned counsel representing the petitioner.
Kindly fix it tomorrow, Lordship.
Released on
kindly tomorrow, Lordship.
23rd of March.
32 also the same, Lordship. 30 and 32.
31.
31, I am put.
Like, because the losses can't see your last order.
February 24 onwards, he is not getting his salary.
25.
Has any report been circulated by the...
It has been prepared, not circulated. Virat.
Alright.
My fault, Virat, it has been not
I
circulated.
appear for the school authorities.
May I circulate here and now, Virat?
Please do. What is the ground?
Virat, kindly takes up the report. Every document used by...
Affirmed on 16th. Why did you not circulate?
On my fault, it has not been done. Virat, prior to your...
Yes, page.
Kindly takes up the report. Page 2, para 4.
First of all, my lord, it's a school run under Article 30.
Hmm.
And second, my lord, the documents used by the petitioner in the writ petition are false.
False.
False. Criminal case has been initiated. The concerned DI and concerned person has been arrested.
All right.
And they have preferred a criminal division application for that they are not being harassed or not being interrogated at the present moment.
And the school is aware that the teacher is working with forged documents.
Yeah, because some notice has been served upon the school also. During the course of investigation, supplementary charge sheet has been filed.
Against whom?
Is this the reason for non-payment of
My lord,
salary?
my lord. His entry
Providing-
was all along false. His entry point.
All right. And is the school sponsored, aided, or DA getting
Minority school.
Fully sponsored.
Yes.
Minority school.
Fully sponsored.
Fully sponsored.
Are you getting complete aid
Well,
or the DA only?
No, complete.
Full. Yes.
Now, may I show my original approval letter?
But then who is going to verify the genuinity of the documents?
What my learned friend is saying is that this has not been issued by DI. Or what is false means what?
I don't know
False document.
Lord, what I sub
if the genuinity of the document is an issue, then the court will not enter.
Just kindly. Now, I take your losses to the approval letter itself, page 18.
I do not know whether
I
it's
tell you losses
true,
kindly,
false, false.
kindly do not say swayed by the simple statement of false.
This is not a sweat statement.
Kindly allow me to say, I have an approved letter. I still have I'm still attending the school, still taking classes.
Let the school take responsibility. Why will the state
But
bear
if
the burden?
approval letter is false, have they withdrawn it? Have they said it to me that this is false?
If it is false, no question of withdrawal arises.
False means what? That's why I'm putting a question to myself. I have false, the signature is false.
If you could put a question to yourself, please find out an answer because you must be knowing it.
Kindly have a look at page 18.
Pay the teacher if the teacher is rendering service, and if you say that
Teacher
it
who
is
is an MSc, a teacher who has BEd, he or he has been selected apropos of process, my lord, because we got the approval from the department. Approval to fill up the post. There is a selection committee constituted. People participated, including the writ petitioner. Ultimately, my lord, the writ petitioner was sailed through in the process, and he was ultimately appointed. It appears from the records, my lord, that by memo bearing number 1104-S/con dated 28/4/2023, Anindo Das Mahapatra, my lord, was approved against, my lord, a vacancy. Now, this approval, they say 1104, according to them, is a false document, according to them. It has been submitted. My lord, with greatest of respect, my lord, it bears the signature of the DI. It has a memo number, and subsequent memo number document has not been questioned. 1105, I also have the document, my lord. It's a separate document. My lord, it has a continuation. I mean, my humble submission to your lordship is, they have today disclosed this report. Had they disclosed it, we will be using our response. We will be also disclosing, my lord, whatever papers we are having as the school authorities. But, my lord, for the present, in the absence of any contemporaneous challenge by anyone to this document, dated 20, my lord, today.
Which page is it?
My lord, this is not this is the approval letter, approval memo. That is a part of the writ petition, perhaps. Our records.
Yes.
Not in the absence of any contemporaneous challenge by anyone. Someone has to challenge it. But today, by making a submission, my lord, on affidavit by an assistant inspector of schools, my lord, we have written to the DI, the school authorities, my lord, the headmistress of the school, on 10th February 2026 has furnished this entire bunch of documents to the DI, to the district inspector of schools, my lord, saying that please examine all these documents and clarify. My lord, someone, I put this question to myself.
Has any answer been provided by the
no,
DI?
no, no answer.
Well, the DI will take steps.
Now, the only thing is the assistant inspector of schools, by relying on some, kindly sees the affidavit, where is and how it has been treated to be false, kindly sees.
All right, you file your exception. I'll see. And the report in the form of affidavit. Affirmed by the Assistant Inspector of Schools, Secondary Education, Paschim Mendipur. Filed in court today is taken on record. Stop.
Well, being authorized by the DI, because direction was upon the DI.
The it will be open for the petitioner and the school to file exception to the same within a period of 3 weeks. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
May I?
Yes, please. Yes.
We'll file the response by Monday week. Keeps it on Tuesday or Wednesday. Kindly. A person is really without salary.
Why don't you at the school? You can always pay.
I have my independent funds to pay our teachers' salary.
It's a aided appointment. Full salary.
I
He has not been appointed even. He has not been appointed even.
Till the court is satisfied that the appointment is proper, can the court burden the state? Tell me this. School can always pay you.
One submission. Kindly see the paragraph affirm.
All right, I'll see later on. Not now.
Tuesday week, may I most
try out other benches, please.
I will do it here. I will do it here.
See the list every day you are coming.
I think it will not take more time.
Kindly, it will not take.
Kindly do that.
On any day,
You
I have
are
been
coming
paid salary once.
Normally paid. You have no negative visibility.
Let us come back to your lordship.
Take it up, your lordship.
Let us come back.
One day or other, take it up.
You come here every day. He comes here every day. You can see the position of the list. What can be done?
Situation. Kindly keeps it 2 weeks.
Do it, your lordship. Once
There are
call for
benches.
explanation, I will do that.
There are benches taking up hearing matters.
But it is, this opinion kindly not with folded hands.
Really speaking.
Kindly
All are broken benches. Friday 3:30, none happens.
And benches
That's
having
practical,
interpretation to hear hearing matters, not irrespective of classification. 4 groups before one honorable judge.
No, I saw some other bench taking up irrespective.
Justice Chatterjee sits in the division bench. I'm taking the honorable judge's name. As and when
Justice Sen with Honorable Mr. Chief Justice.
Kindly, I wouldn't have pestered your lordship, kindly. We want to do it here, we lose, we win, whatever happens here.
Monthly list of April.
Under the monthly list of April, কি আছে?
topic করিয়ে দিন না, সেটা তো
kindly under the same heading, your lordships.
There must be a limit. Otherwise, I'll add up all matters, hearing matters, bundles, and then you'll fall in trouble.
Under motion.
Not under hearing.
To be mentioned.
To be mentioned.
We'll do it, your lordship. Heading down, will do anything.
Great.
Yes, 32.
Upgrade
Similar. 32, same order as 30.
হ্যাঁ তো বটেই তো সেটা তো
33.
But,
33, you are also there in 33?
33. Both the petitions have been tagged
Yes.
by my lord's order. But I'm the suspended headmaster. But 33 on the last day, your lord, right? Kindly have a look to page 30. Item number 33 once. But in this matter, no. 33 is 21633. But in 33, and Joseph ki diyechen file ta?
Yes, yes.
But on the last day, I have handed over one judgment of the of Justice Ajoy Gupta, where the criminal proceeding which was initiated against me by one of the student of my school, but the FIR and the charge sheet has been quashed. But the observation of Justice Gupta, but I want to kindly have a look to page 22 of the judgment of Justice Gupta.
Is it separately given?
Yes, yes, yes. I have handed over the copy.
Wait, I'll see.
Because the second petition was not there.
I can see a supplementary affidavit. Second petition to etai.
But in the second petition, the judgment of Justice Gupta is there. Is at page 46.
Yes.
46, 47. 47.
Petition.
Second petition. 2025.
Yes.
Let the court found.
No, whatever. It has been quashed. Now it remains.
Now, the suspension order had not been revoked. Now, your lordship kindly turns to the new petition.
Yes.
2025. Well, in the new petition, what I have challenged is the fresh order of suspension. Well, kindly have a look to page 50. 50.
Yes.
But by this order, yes, of the 2025 petition, page 50.
57 to 50.
50. But by this order, it has said that the jail custody case of Panchananda Jana, suspended headmaster. Enclosed, please find here the order passed by the president of the so-and-so in respect of the jail custody case of Panchananda Jana for taking necessary action. This has been written to the president of the school. It was sent on 22nd of September 2025. Then, your lordship will have a look to page 52, the order of suspension. Subject is very interesting. Jail custody of the case of Panchananda Jana, suspended headmaster. Page 52.
Is this the impugned order? Yes. All right.
Well, at the Mr. Sri Panchananda Jana, headmaster of the school, was suspended by the board until further orders with effect from the date of his arrest on 23rd, but the date is very important, 23rd of March 2024, as per Rule 6.1 of the so-and-so rules. Then, in connection with Mohishadal PS case number so-and-so. Now, the order of the High Court dated 28th August 25 has allowed the CRR so-and-so and quashed the charge sheet submitted by the Mohishadal PS. However, the inquiry report of the DI of the school AC Purbo Medinipur bearing number so-and-so dated 25th of November 2024 concluded that the headmaster violated financial norms and misused the power of an office head, and the resolution of the managing committee dated 19th of December 24 resolved unanimously that the presence of Sri Jana will be detrimental for the overall academic environment of the school. The petitioner was not there since March 2024. So how the managing committee can take the decision in December 2024 that my presence in the school will be detrimental to the interest of the school? Then, at present, considering the gravity of the complaint, the board has decided to seek a more detailed report and comprehensive evidence-based inquiry report encompassing all factual records from the DIS of schools Medinipur by 21 working days to proceed further with the case. Hence, it is hereby ordered that the suspension of Panchananda Jana, suspended headmaster, shall continue in contemplation of the disciplinary proceedings under 6.1c of the board so-and-so. But I pause here for a moment. But kindly have a look to the rules once. Suspension. That's a boita. New book. Yes, yes, that book, one.
Well, I'm handing over, Lordship.
Oh, you have a copy?
Yes, we am cut.
Copy আছে?
Lordship কি দিয়েছি?
আচ্ছা।
My lord, page খুলে দিই।
6, rule 6. I got it? Rule 6. The board, 6.1, the board may, on the following reasons, issue the order of suspension against the teaching and non-teaching staff. If the teaching and non-teaching staff is under detention or in lawful custody for more than 48 hours, but I was there. Now it has gone. The case has been quashed. Then, for an alleged misconduct, not there. C, if there is reason to believe that unless the concerned teaching or non-teaching staff is suspended, it may result in tampering or destruction of the evidence, or the concerned teacher or non-teaching staff may cause undue influence in disciplinary proceeding pending or contemplated. But here I pause for a moment. But I was suspended because I was arrested on 23rd of March 2024. The report, which has been taken care of by the board, it said that the resolution of the managing committee was taken on 19th of December, after 9 months of my arrest. So in this 9 months, what wrong I have done, this was never depicted before the board or before the DI. This is number 1. Or before my arrest, I was there in this school for 4 years. Not a single allegation was made by this managing committee or the president to the board. Because the, rule 5A, 1A, but kindly have a look to the rule 5.1A. Suspension can be issued. Disciplinary proceeding can be.
Has anything taken place after page 52?
Show cause issued.
Disciplinary
No,
proceeding.
we have issued show cause. Show cause issued, my lord, long back in December 2025. Thereafter, reminder was given in January 2026, and we have received the reply of show cause on the 16th February this month, 2026.
Take a decision as to whether you will initiate disciplinary.
No, my lord, that is already there. Why I submitted, lordship?
On a different point.
My lord, may I submit? Here, may I submit? Acha korun.
May I? I'm absolutely on a different point, but it's a point of law. If your lordship kindly have a look to the last paragraph of page 52. Hence, it is hereby ordered that the suspension of Ponchananda Jana, suspended headmaster of the school, shall continue in contemplation of the disciplinary proceeding against the Jana 6.1c. But I was suspended under 6.1a. The moment the FIR and charge sheet has been quashed, the suspension goes automatically.
No.
Let's just make submission.
But the suspension, because I have been suspended because I was in jail custody, the moment the High Court quashed it, my suspension will go automatically because the criminal case is not standing in the way, or the existence of the criminal case has gone. Now, if the suspension is gone, then fresh suspension order has to be issued under 6.1c, because 6.1a and 6.1c are absolutely different from each other. This is my first submission. Second is, they are continuing. How it can be continued? Well, your lordship, kindly have a look to the order of suspension. Not a single document, not a report or the copy of the resolution of the school has been handed over to me. A person has been suspended, that my entry to the school will be detrimental to the interest of the student and the school. When the High Court in August.
Alright, I've followed.
Your lordship, there is no such rule which says that once a case is dropped or released on bail, the suspension goes automatically, because I asked my learned friend to show such rules. So there is no such rule. Now, your lordship, in this particular case, my lord, the allegation against the headmaster was under POCSO, a student of that particular school. Now, your lordship, when he was arrested, not automatically he was under him, suspension was there. Your lordship, what board did, my lord, after the case was dropped, my lord, board asked the school authority he prayed before the board for withdrawal of suspension. So asked the school authority said in the resolution that his appearance in the school will be not good for the environment of the school. So, well, the board has given your lordship the DI, and following the rules, your lordship, when he is under suspension, asks the DI to hold a preliminary inquiry. So, my lord, in the preliminary inquiry, my lord, apart from this allegation, there are some other allegations. So, now board has decided to proceed against the headmaster. Now, my lord, these rules says that, your lordship, in what ground the suspension may continue. My lord, if there is a reason to believe that, because he is a headmaster, that unless the concerned teaching or non suspended, it may result in tampering of the destruction evidence.
Is
so, my lord, there is no automatic
a
withdrawal of suspension.
suspended headmaster of a school.
Am I allowed to submit my instruction from DI 2018? The petitioner is not cooperating in inquiry mine.
But may I know what?
He was informed to come before the inquiry. He did not attend.
But inquiry where? Inquiry into the school.
And, your lordship, show cause issue.
Where is the issue? Why you did not come?
Well, I am the suspended headmaster.
Suspended headmaster.
How can I enter into the school? What the DI is saying?
He was put under suspension as he remained in custody for more than 48 hours. Stop. The complaint relying on which the criminal proceeding was initiated stood set aside by the court with a judgment dated 20th August 2025 in CRR 3857 of 2024, page 26. The charge sheet submitted against the petitioner stood quashed by the court. Stop. The petitioner submits that immediately on quashing of the complaint and the charge sheet, the suspension order stands revoked automatically. Stop. The President of the Ad hoc Committee, West Bengal Board of Secondary Education has issued further suspension order.
No, Malay, this is not a suspension order.
Continuation.
It is not a new suspension order, Lordship, because it is written already suspended HM. Refused to withdraw the order of suspension.
Has passed order on in September 2025 by continuing with the order of suspension and a disciplinary proceeding as per rule 6 within bracket 1 within bracket C. Now, continuation of the suspension in contemplation of a disciplinary proceeding. As per rule 6 within bracket 1 within bracket C of the West Bengal Board of Secondary Education, bracket open, appointment, confirmation, conduct and discipline of teachers and non-teaching staff, bracket close, rules 2018. The petitioner is aggrieved by the same. Stop. It has been submitted that the board could not have continued with the suspension order as the initial order of suspension no longer survives after the criminal case stood quashed by the court. Stop. The reason for issuance of the order for continuing the suspension is absolutely bad and illegal. Stop. There is nothing on record to suggest that the petitioner violated any financial norms or misused the power of office of the head, as the petitioner was arrested way back on 23rd March 2024, and since thereafter he did not have any opportunity to visit the school. Stop. The question of misusing the power of the office as on 25th of November 2024 does not arise. 25th November 2024 does not arise. Stop. Prayer has been made to set aside the impugned communication, continuing his suspension, and to permit the petitioner to join service. Stop. The aforesaid submission and prayer of the petitioner is opposed by the board and the state respondents, particularly the District Inspector of Schools, Secondary Education, Purva Mendipur. Stop. Learned advocate representing the board submits that there is no provision for automatic withdrawal of suspension. Stop. The board conducted an inquiry through the District Inspector of Schools, and on receipt of the inquiry report, the board contemplates initiating disciplinary proceeding against the petitioner. Stop. A show cause notice has been issued and a reply to the same has been filed by the petitioner lately.
After 1 year.
After a year of
Let,
issuance of the same.
No, Malad, I stand corrected. This is wrong submission. Malad, it was there. Thereafter, Malad, we sought for documents because no documents were submitted.
Not required, Your
Yes,
Lordship.
The
No provision, Your Lordship.
Malad, we sought for document. When the document was submitted to me, then I replied.
Learned advocate representing the District Inspector of Schools relies upon the instruction forwarded by the aforesaid respondent signed on 14th of October 2025, submitting that the petitioner was directed to attend a hearing
at the school. How
but
can he come?
despite several communications, the petitioner remained absent in the inquiry. Stop. The inquiry report of the DI has already been forwarded to the board. Stop paragraph. Learned advocate for the petitioner justifies the reason for delay in answering the show cause. Stop. It has been submitted that as the petitioner was suspended from service, he was not in a position to visit the school to attend the inquiry. Stop paragraph.
61C, Malad says, I have
submitted. I have heard the submissions made on behalf of all the parties and have perused the materials placed before the court. Stop. Admittedly, it appears that the petitioner was arrested on 23rd March 2024, and as he remained in custody for more than 48 hours, he stood suspended as per Rule 6 within bracket 1 within bracket A of the rules. Stop. The criminal complaint against the petitioner stood quashed by the court on 20th August 2025. Stop. The petitioner, now the contention of the petitioner that on quashing of the criminal proceeding, the order of suspension automatically gets revoked is not backed up by supporting laws.
Malad, I have sought for revocation. The document is there.
The petitioner made application for revocation of his order of suspension, but the same has not been allowed by the authority. Stop. The same implies that the suspension under 6(1)(a) still continued. Stop. The authority thereafter invoked the provision of 6 within bracket 1, within bracket C, for suspending the petitioner in contemplation of initiating disciplinary proceeding against him. Stop. The impugned order of the board clearly mentions that the inquiry report of the DI suggests that that the petitioner violated financial norms and misused the power of office of the headmaster. Stop. Whether the allegations against the petitioner are proper or not can be ascertained only after the board proceeds with the discipline board initiates the disciplinary proceeding against the petitioner. Stop. The petitioner will have enough opportunity to defend himself in the disciplinary proceeding. Stop. The prayer of the petitioner, comma, at this stage, comma, to revoke the order of suspension cannot be allowed. Stop. The writ petition fails and is hereby dismissed. Stop. The board is directed to take a decision whether to proceed with the disciplinary proceeding against the petitioner. Stop. Dismissed.
Well, no time frame has been given to the board.
It is not. It is in the rules, Your Lordship. Accordingly, it will be done.
The board's discretion. Hopefully, they'll do it early. Otherwise,
Since
you
2024.
come all over
The
again.
charge sheet will be issued very soon. That is my
Your Lordship,
instruction.
my lord.
Well, both the petitions, both the writ petition dismissed.
Both.
এটা তোমার both the petition dismissed.
Other, what is the prayer in the other one?
The first one
First
for
one.
revocation of suspension.
Same.
No, this is that is regarding connection with the criminal case.
Anyway, now it has merged to one.
Very well.
Dismissed.
Great.
Highly obliged, my lord.
There was a direction to file an exception to the report. But I'm just seeking some extension so that I can just 2 weeks extension may be given, my lord. I'll respond to this report. It is regarding that upper primary, my lord, the below ranked candidate has been preferred over the petitioner. So there was a direction, my lord. Just give me it is.
On the prayer of the learned advocate representing the petitioner, comma, time to file the exception to the report filed by the commission stands extended. Stop. What is your prayer?
My lord kindly appreciates that the below
Appreciation. What is your prayer?
in the writ petition.
Yes.
Since the below ranked candidate has been given the appointment, I am more qualified. I should be given the benefit prior to her. Because my lord, if your lordship recalls, there were the numbers of 81, she got 80, that calculation. So I am entitled to be called in before her. I don't mind she getting job. I should also be getting the opportunity.
Released in the combined monthly list of April.
Or any date may be given, my lord.
Yes.
March.
6th of April.
No, March, my lord, kindly March.
It won't be possible.
No, kindly, my lord, monthly list of March at least. My lord, kindly monthly list of March at least.
26.
Lord, item number 36, I appeal for the state respondents. Lord, your lordship was kind enough to grant me a leave to my lord, file a second report from the block development officer. But I was humbly praying for a fortnight's more time. My lord, I had a personal talk with the block development officer, my lord. But he was seeking a fortnight's time because of this Mr. SIR issues, my lord. He had not been able to make up the report, my lord. But only fortnight's time. In the meantime, the entire report will be there with regard to the family income of the petitioner. Individual.
On the prayer of the learned advocate representing the state respondents, seeking extension of time for filing the report, comma, hearing of the writ petition stands adjourned till 24th of March.
Grateful, madam.
The report shall be prepared and circulated by 20th. Puri.
Grateful.
It is,
Yes.
and for the petitioner, my lord, it is that matter where the 90 days extendable up to 60 more days and 150 days. I made the application for extension that was not considered. I placed, my lord, rule 17, which gives me a chance for being considered by the commission. Rule 17 proviso.
Yes.
It's 90 days. And then, my lord, in my case, there was no consideration. My lord,
The
in
commission was directed to revert with instruction as to whether the application of the petitioner seeking extension was at all considered or not.
Yes,
It was considered.
it was considered, but the document I could not get. What I discussed with the chairman, he has told me that yes, because what is done in case of the rejection, because those who get it are intimated and reason orders are passed. So he told me that each rejection with a notice put onto the application that there is no valid ground. He has also shown me some of the samples, but the petitioners we have not yet managed to trace because we are not preserving them in a very systematic way because we do not require to preserve them. But if the court desires, then if a little time is given, I will try to come back with his application where we have put in the note that no.
Then how does it help? This goes on and on.
No,
isn't it?
The rule does not require that I should preserve or I should.
Rule does not require so, but my lord, when
Then
it
it
gives me
can-
a chance for being considered, I must know the fate of my application.
It is rejection. Now they'll communicate. Will you be happy? Then there is no chance.
Because my lord, because it is dealt on case-to-case basis.
Yes.
Who is to be given or not? At least in which parameter they are allowing and which parameter they are not allowing, I am entitled to be made aware of. I do not know what was the fate of my application. In some cases,
Please come.
medical ground has been allowed. Others have been
Learned
allowed.
advocate representing the commission
37.
submits upon instruction that
37.
he has received oral instruction from the chairman of the commission that the application of the petitioner seeking extension of the validity period of his recommendation letter was duly considered and rejected. Stop. The petitioner has not been formally intimated such rejection, as the rule does not require intimation to the candidate once the prayer for extension of the validity period is rejected. Stop paragraph. The at such a late point of time, there is hardly any scope to grant any relief to the petitioner.
Well, may I just make one submission? It has been allowed by, in the similar nature case, court had directed the commission to consider. I had, perhaps I had.
No, sorry, I am not agreeable.
I am entitled to get at least know on which parameter I can challenge that also. But I would not be knowing my fate of application under the statutory provision of law.
The writ petition stands dismissed. Stop. The commission, however, is directed to intimate the petitioner, not intimate, communicate the petitioner the order of rejection, the rejection. How do you say it's an order of rejection? No. You just write it in the body of the application that it is rejected.
As an endorsement.
Endorsement.
There is a memorandum also.
The reason will be communicated.
Yes.
The reason for rejection of his prayer. How soon can you do it? Do I fix a time limit? 4 weeks will be all right with you?
Kindly do not fix a time limit. We will do it within.
And then he'll again come.
For that again, I have to come.
Then 4 weeks.
6 weeks.
6 weeks. Very well.
My lordship is disposing it of.
My lord, my junior is appearing online.
Can you not dismiss it, my lord?
Ms. Dubey is appearing online.
All right.
Let it be disposed of in that case.
Next.
Grateful.
Briefটা দেখাচ্ছি, এটা brief আছে।
Madam, for the petition, I'm led by Mr. Shulito Dasgupta. He is engaged in another court.
Where is your
Madam,
report? Exception to the report. Has copy been served?
Yes, madam. Yes.
What do you want, adjournment?
Yes, ma'am.
What is the matter?
My lord, it is that matter where, my lord, special educators, the petitioners wanted to be given a chance or a go at
Second SLST?
First SLST.
First SLST.
special educators.
All right, special educators. Is the examination or process going on? What is the stage?
Schedule has not yet been published, but we have written to the education department to give us the date so that we can start. So our process is
on.
It is almost ready, but again, we have other selection processes which we are looking after. So maybe there is some time in hand. Maybe.
This petition, what has fallen for consideration is whether the petitioners working in the DEIC nodal centers will be allowed to participate or not. Because whether it is
Did they file their application? No.
Yes, Lordship, they have filed.
You have filed your application?
It's after filing the petition.
The application is filed.
That is
And is it under consideration or rejected at the very first stage? You do not know.
That unless it goes to the verification stage, it will not be rejected. So you will go through the written examination.
So the entire process, the petitioners will be permitted to appear.
application file করেছে কি?
সেটা আমি জানি না, সেটা তো
Application whether it has been filed or not, because in the writ it petitionটা হয়েছিল।
And exception to the report. Exception by the petitioners to the report filed by the commission. In court today is taken on record. Stuff. An accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stuff. On such prayer, release the matter for further consideration on 30th of March.
I heard release. List, I heard release, I was taken away. Great.
Deeply obliged.
Petition. For the petition.
But this is the matter for compassionate appointment. Lordship, kindly first sees my lord's last part 1, 19th of January's order, and then my lord the February 10 order.
কি ভ্যাকেন্সি পাঠানো হয়েছে? কবে পাঠিয়েছে?
কমিশনার অফ স্কুল এডুকেশন
কবে পাঠিয়েছে? দেখি দেখি কি ইনস্ট্রাকশন আছে?
You are for the state? Let me see your instruction.
একটাই কপি
Your clients will never give more than 1 copies.
No, my lord. For state cases, my lord, whenever they come to my lord, give the instruction, they gives only minimum 3 copies.
Has been
তুই চাও না তাই
চাইলেও পাওয়া যায়।
যারা দেয় বা তারা ঠিক 3 কপি করে নিয়ে আসে মানে যারা আমরা না তুই অ্যাড
The board has been intimated the vacancy status only on the 19th of February 2026.
Yes, well, my instruction is last week I have taken that we don't have any vacancy in Udia medium, Group C, this particular district.
Vacancy has been forwarded. I have seen the instruction. Vacancy has been forwarded to the Commissioner of School Education. Board has been intimated about the status.
Intimated, not forwarded to us.
Can you see the annex letters? Can you see?
Kharagpur Utkal Vidyapit is the place. Take a photocopy from your learned friend.
Yes, madam. Yes.
Take a photocopy from your learned friend.
I'll do that.
And you hand it over to the
My land senior.
yes for the board
I'll do
so
that.
that she can take further steps in the matter.
Yes, madam.
Please come.
But they're just going on passing the balls, my lord, from one to another.
Hey.
Passing
Yes.
From the report forwarded by the District Inspector of Schools, Secondary Education, Paschim Medinipur, it appears that vacancy in Group C post at Kharagpur Utkal Vidyapit has been identified, and information of the same has been forwarded both to the Commissioner of School Education and to the West Bengal Board of Secondary Education. Learned advocate representing the now who is going to take steps in the matter?
Well, now the Commissioner of School Education will forward the vacancy to us. It is only intimation, it has not been forwarded. After we get the vacancy, my lord, we will.
To the commissioner also, it is only an information. But
So,
then the memo number is there, the date is there, so you can get it from there also.
No, my lord, it is formally, my lord, Commissioner will send us the vacancy. And my lord, after we get the vacancy, we'll forward it to the commission. And thereafter, commission will look in their panel whether this person is coming in the panel 1, 2, 3, whatever. And if there is a chance of this person, then he will get an appointment. They will make recommendation to us and we'll issue appointment letter.
The memo number and the date of the communications made by the DI are available in the instruction forwarded by the DI, signed on 19th of February 2026. A copy of the same has been handed over to the learned advocate representing the board and the commission for taking further necessary steps in the matter. Released on 17th of March 2026, the follow-up steps taken shall be intimated to the court on the adjourned date. Make a copy for you and for them also.
Circulate,
The state will not be able to do it.
Great.
17th March.
এটার একটা কপি দিতে ওনাকে কপি করে এক্ষুনি দিয়ে দেবে।
But the memos are also annexed. Memos are there.
Right. Then it will be good. You can work on the memos also.
Yes, I পুরোটাই করে দিচ্ছি। Video visual.
You can make for WhatsApp.
Yes. He is very efficient, but he will.
You are no less. Next.
40 my lord, I am for the petitioner, my lord.
I am for the state.
There was a direction to file a report, but we have not received any copy of.
We are yet to file our report in this one.
His name has been wrongly recorded in the list of tainted candidates.
He was wrongly recommended.
Recommended.
He was recommended by the School Service Commission despite not being inside the panel.
Oh, and that it is in the list of tainted candidates.
He is in the list of tainted
candidates. But then what more to do?
He says that why he is in the list of tainted candidates, that we have to substantiate by way of a report.
But considering all the aspects, my lord, your lordship was pleased to call for a report. Well, let them come with the report, my lord. We shall file our exception, because what happened, my lord, the wrong, if there is a wrong, the wrong has been committed by them. I have not been qualified for the interview also. Now, my lord, after issuing the admit card and after being allowed me to participate in the written examination,
Go before the criminal court and get your name struck off from there.
My lord, only one thing, my lord, since your lordship,
one thing, two things, nothing.
My lord,
nothing.
This tainted, my lord,
Sorry, I cannot do it.
My lord, I am completely putting this question to myself, my lord, what wrong I have committed.
Find out an answer for yourself. The Supreme Court has given the answer and I'll follow that. Please stop.
Because in the 2022 process, my lord, when the my lord, only one thing, my lord, only one thing. My lord, kindly see the order passed by this Honorable High Court, my lord, by dint of which, my lord, they have published the list at page 66.
The petitioner's name features in the list of tainted candidates published by
page 66, my lord, once, my lord.
Commission. Stop. The petitioner is aggrieved by the same. Stop. Submission is that the reason for taint is not disclosed.
Disclosed. It has been disclosed that I have been wrongly recommended by them.
Despite not being inside the panel.
Acha, chale likhun. Submission is that the reason for taint discloses that the petitioner was wrongly recommended even though his name did not appear in the list of recommended candidates.
And I did not opt the service also.
In short, he was out of panel.
The petitioner did not join the service. Prayer has been made to direct the commission to remove his name from the list of tainted candidates. Stop. The submission of the petitioner is akin to the submission made by some of the tainted candidates before the Honorable Supreme Court in the matter of Boishaki Bhattacharya. Stop. In paragraph numbers 38 and 39 of the judgment dated 3rd of April 2025, the court clearly the court considered the said submission and was of the opinion that the issue of authenticity of the data need not be decided in the proceeding, as it falls under the purview of the criminal court. In the writ proceeding করবেন ঠিক আছে purview of the criminal court. Stop. Whether the petitioner's name has been rightly incorporated in the said list or not has to be decided by a separate competent forum. Stop. The writ court is not the appropriate forum to take a decision apropos the prayer of the petitioner. Stop. Next, in view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Next.
Obliged. আমি দেখিয়ে দেবো
Application. Order for the petition. But this matter, this morning, another matter was taken up by this honorable. I'm sorry. But Lordship has been pleased to post this matter, my lord, where my learned senior Mr. Kollol Basu was appearing for the petitioners. Also, we have posted the matter tomorrow. So, my lord, if
You want this matter to be taken up tomorrow?
if all these matters were, my lord, on the same points previously was being taken up, my learned senior's matter was also there. If your lordship can take it.
As to whether, as a one-time measure, since the AG is here, let me hear.
Very well.
Because he may not be available
Very well.
tomorrow.
But
Maybe busy somewhere else. As a one-time measure, whether the petitioners may be permitted to join their previous job, relying on the order of repatriation issued in their favor, keeping in mind that they are untainted candidates and were previously in a different job. One-time measure, extension of time to join. Paragraph 13 of the earlier order dated 17th of February. 13 and 14. Looking at the order will not help you, learned AG. You need instruction from your client.
I have the instruction.
Then please.
Here is a case, my lord, where your lord, the orders of the Honorable Supreme Court, your lordship is aware, my lord, I will not trouble your lordship with those. But so far as, my lord, this petitioner is concerned, my lord, kindly have a look to, my lord, page number 55.
If you argue on merits, then it will be something else. I have given a free hand to you. Take a decision as a one-time measure. If they can be allowed to revert, they are under your services. They are right now involved in the election duties and everything. The invigilation, the examination of papers and everything. Untainted candidates, 2016.
Yes.
Supreme Court has given them time.
Difficulty is because I may put myself into violation of the court's order. Maybe.
You may not.
Because the Supreme Court had fixed
No,
the
sir. No, sir. This point has been kept open. If further issues arises, and that has also been considered in this order.
Yes.
And I have recorded that because I remember that was the submission that the state would not like to violate any of the direction passed by the court, and that was considered, and thereafter this order was passed.
Yes.
If you want to revert, please do.
Lord, your Lordship may kindly have a look to the order of the Supreme Court dated 17th November.
Contempt order.
First, kindly take me the 19th September order.
Don't go to September, 17th November.
Yes.
The court directed that if the petitioners have any other grievance, they would necessarily have to seek redressal thereof in an independent proceeding, and this is the independent proceeding that the petitioner has filed.
Yes. Now, Lord, so far as will be any other grievance.
This is
This
another.
This is not an any other grievance.
Absolutely a different grievance. Seeking extension of time to revert. You have given them the time.
Please consider one thing. When the Supreme Court has fixed a time, I have no quarrel with them. Supreme Court said that those persons who were already working somewhere else, if they apply to go back to their respective positions, the state government will
take a decision.
Take a decision, put them back, if required, create supernumerary post. There is no ambiguity in that, there is no hesitation in understanding that. Thereafter, what is done is, my lord, your lordship will find, my lord, that these people, they were, my lord, allowed time to join plus extended time. That is what I wanted to show your lordship at page 55.
It is admitted. It is admitted.
Now, my lord, please consider one thing. My lord, if the petitioner themselves create a situation and generate a grievance, will the order of the Supreme Court be of any? It was their choice. When we had allowed them, they please come and join. They don't join.
For what?
Whatever reason.
No, they have said that they were in the midst of a session, academic session. The Supreme Court allowed this benefit only to the teachers so that the students do not get hampered.
Please have a look at page 55 and 56. Please have a look to these pages.
It is very strange that the state is...
the state has already offered. This is not a case where the state did not offer. I can understand that the state did not offer, they may have a legitimate grievance. But when the state offers them, they don't, accept it and then say that I have a grievance, therefore Supreme Court has permitted me. Possibly, my lord, the Supreme Court intention is not to permit a person to generate a grievance and then seek redressal of a grievance. But I can understand at the instance of the state, my lord, some problem has been created. Of course, my lord, they have a right. Please have a look at page 55. But I cannot say what I cannot say in open court, but please let us go by the records. Let us go by the records. Please take page 55. But this is 15th of October 2025. Please skip over the first 7-8 line. Then we are in bold. So and so Siporna Chaudhary is hereby allowed to continue in his service as assistant teacher in such and such. She is therefore directed to resume duty as assistant teacher in such and such within 30 days from the receipt of this letter. The state has done its job. It is made clear that the instant letter is issued in strict compliance with and in due adherence to the directions in para 47. Now, please take with the next one, which is at page, which is 13th of November 2025 at page 60, which is in continuation with 56. In accordance with the memo dated 1510, the chairman of so-and-so, a joining letter was issued to the below noted candidate to the post of so and so in such and such in terms of the direction in para 47 of such and such along with analogous matters and read a memo dated so and so issued by the commissioner. Details of his candidature and place of posting is such and such. She has prayed, read a letter to extend his rejoining time due to unavoidable circumstances. Therefore, his adjoining time is hereby extended. What else more can we do? He has asked for extension, we have extended.
As a one-time measure, can you take any other decision now?
As a one-time measure, it is for one person. If it is for one establishment, one can understand. I do not know how many people are waiting in the wings.
True. This I admit. There may be several others who have simply taken a chance to appear in second SLST, and now when they do not get a successful rank or a position over there, they want to revert.
Yes.
This is very apparent, right?
Yes.
But then, can something be done for these candidates who lost their job for no fault of their own? This is the thing that is playing through the mind of the court. Nothing more.
I quite appreciate, but at the same time, your lordship may kindly consider. I have issued a letter. Page 55.
I do not say you are at fault.
May I say this? May I say this? Where somebody has come before the court of appeal.
Yes.
I had issued a letter under paragraph 47. They asked for extension of time. I have also extended the time. The writ petition is affirmed on 2nd of February 2026. Now, what were they doing, Millard, in between? Nothing. No explanation.
They were taking a chance in a second SLST.
If the court permits that, I have nothing to say. If the court permits that, Millard, let that be, Millard, recorded that they were taking a chance. Therefore, they can, Millard, give a go by to my offer.
All right.
And if they are not successful over there, I have to then again apply para 47 of the Supreme Court judgment.
No question.
That is
the
what
way
they are asking.
you are putting it.
Yes.
That is not the way. Can you please say as to what these candidates were doing from 31st of December you've permitted, you showed me page 60, 31st of December till which the candidate could have joined, right? From then onwards, the candidate was sitting at home. The candidate was not doing service in the school or wherever they are, right? Whether you have engaged them in the election duties or not, in invigilation, in any other thing. If you say that, yes, they were not doing anything, they were simply waiting for the result of SSC to come out and see whether they are.
I am not saying anything.
Admittedly,
I am not
these
saying
candidates.
What I am saying is,
how much leniency can be shown to these candidates?
I am putting a question to myself. Being at the receiving end, I am putting a question to myself. Number one, have I disobeyed the order of the Supreme Court? Well, the possible answer is yes.
Yes, the court admits that there is no fault, error on the part of the respondents. On the very first day, I had made myself clear, and that is the reason only a one-time measure, if it can be taken, considering the fact that they had a job and they lost it. The life and livelihood of these people are involved. Nothing else. I do not say.
The Supreme Court was
all right.
very
Followed.
sympathetic
Please
about.
In furtherance to the direction passed by the court on 17th of February 2026, the learned AG has appeared before the court and has submitted that it is not possible to accommodate the petitioners. It is not possible to permit the petitioners to revert to their previous job, as the same would be contrary to the direction passed by the Honorable Supreme Court from time to time. Stop. Paragraph. It appears that Vide order dated 18 December 2025, the Honorable Supreme Court permitted the untainted teachers already appointed to continue in service up to 31st of December 2025. Stop. The where are the other Supreme Court orders that you are relying upon?
The first one is 3rd April 25, then second is 17th April 75, then 18th of December, which is at page 53.
Thereafter,
then 19th of September 2025. This is in the contempt one. But I think that is
not on record. What are the dates of the orders?
19th of September 2025.
The orders that I handed up to your lordship,
7th of October 25 and 17th of November 25.
What I have handed up to your lordships are 26th of November 2025.
Yes, 26th of November in Vivek Parya. No. It's not Vivek Parya.
Late 2025.
Video order dated 17th April 2025. The court not video, in the order dated passed in the matter of Boishaki Bhattacharya. ওপরে কি বললাম বৈশাখী ভট্টাচার্য বলিনি না ওটা লিখতে হবে হ্যাঁ এই যে State of West Bengal versus Boishaki Bhattacharya, Chatterjee and others. The court accepted the prayer of the West Bengal Board of Secondary Education and the state to allow the untainted teachers to remain in service till 31st of December 2025. As the court did not want the students undergoing study to suffer on account of lack of teachers and lapses and failures, which resulted in nullifying the appointment, nullify the entire selection process and the appointments made thereunder. Stop paragraph. In terms of the direction passed by the Honorable Supreme Court on 3rd April 2025, in paragraph 47, comma, opportunity was granted to the petitioners to revert to their earlier job. Stop. Time to join the earlier job also stood extended by the authority till 31st of December 2025. Stop. Next. The petitioners claim that as they were in the midst of the academic session and they were also involved in the work of involved in various other works related to the school and also in election duty, comma, they were unable to revert within the extended time period. Stop. The time to conclude the fresh recruitment process stood extended by the Honorable Supreme Court till 31st of August 2026. Give me that order also.
18 December. It's an
18 December.
Lordship, I have handed up already your Lordship.
18 December.
53 থেকে শুরু হচ্ছে 54. That your Lordship will find, my lord, at my writ petition.
53 at page 54 of the writ petition.
No, till August 26 it has been extended. Where is that?
Here,
Date?
54. Page 54. Fourth line from top.
Oh, acha. 18 December. Till 31st of August 2026. Date-টা বললাম order-এর? কি বললাম? Sentence-টা শুরু করলাম কি দিয়ে? 31st August 2026 or prior thereto, with a order dated 18 December 2025.
But if your Lordship may permit me to add one sentence over here, please look into the next paragraph at page 54. Possibly this order does not cover those who have opted for other jobs or to go back to their previous jobs. Looking at the second paragraph. Possibly, this is my reading of it.
Untainted teachers already appointed, permitted to continue up to 31st of December, shall continue to hold the post till completion. What does this mean?
Hold the post. Therefore, those who opt for somewhere else or go back to their previous one, for them, my lord, holding it till 31st of December doesn't arrive. That situation would not apply to those persons who opt for going back.
This paragraph is not meant for them.
Highly request.
Doesn't matter.
I may be wrong. Please record this.
All right.
Because possibly this will not apply to those, because if I opt for my
Another
previous job,
school, it goes on.
yes,
There
then
is no
I
end
go
date.
back to my own place.
There is no end date.
Yes, therefore, on 31st of December,
So this is not related to them.
this, yes, this is not related to these persons, like
Yes.
the petitioner before your lordship.
How are you relating this to this matter?
May I say this, Lord? If I am a person, I mean, I speak for the petitioner.
Yes, yes.
I am a person who have opted for going back to my
Earlier job.
earlier job. The government is bound to allow me under para 47. Therefore, I apply, the government will go and join on so and so date. Now, for me, fixing a cutoff date that you shall continue up to so and so date doesn't arise, because for me or people
Yes,
like
yes,
me,
yes.
therefore, according to me, the second paragraph which says that we make it clear, the first part is for completion of the process, the date August. The second part is
Yes.
we make it clear that the tainted teachers already appointed who were permitted to continue up to 31st December shall continue to hold their post till such date of completion. Now, these people will continue till 31st of August 2026.
We have been continuing.
Which does not apply for people who have opted for going back to their own positions or previous position. This is my submission or my understanding. My understanding may be wrong.
We have been continuing, Malad, till 31st of December.
Whatever may be the reason, but your authority permitted them to continue till the 31st.
No, we did not permit. But
Extended.
Their situation is different. Their situation is that they have opted, we have allowed, then they said we have got some reason not to join within the time you have given. Please extend it. We have extended it. Thereafter they did not join, therefore they are before you. So for them this would possibly not apply. In that case, they should have changed their prayer by saying that since Supreme Court has extended it in 31st of August, we should also be allowed to work till 31st of August.
They are at your mercy, sir. Absolutely at your mercy.
I can understand what is passing through the mind of the court, but I have also some
All right, then leave it to the court.
Yes, that I have to at the end of the day.
Yes,
But
yes.
please record this submission possibly, because otherwise I may be failing in my duty.
All right. কি বললাম? আচ্ছা, ওখানে শেষ হয়ে গেল, তাই তো? In paragraph 47 of the judgment, dated 3rd April 2025. The Honorable Supreme Court allowed the untainted candidates of the 2016 recruitment process who previously worked in different departments of the state government or with autonomous bodies to apply to their previous departments to continue in service with those entities. Stop. The court directed that the applications must be processed by the respective departments within 3 months, and the candidates would be allowed to resume their positions. The court also held that the period between the termination of their previous appointment and their joining will not be considered a break in service. Their seniority and other entitlements will be preserved and they will be eligible for increments. Stop. If required and necessary, comma, supernumerary posts may be created for these persons appointed in the interregnum. Stop. The petitioners, though applied for reversion to their earlier position, but at the same time took a chance for securing fresh appointment in the recruitment process that is being conducted in accordance with the direction passed by the Honorable Supreme Court. Stop. The petitioners have not been able to make it to the merit list. None? Not if some have?
Yes.
All right. And even then they want to revert?
Yes, my lord, some of them, yes, they do. But even in spite of the fact they have not made it to the merit list, but still, my lord, let me just submit to your lordship, nothing is finalized now.
আচ্ছা তাহলে এই লাইনটা কাটুন as the recruitment process is not yet over and the petitioners are not sure as to whether they will get the job or not, comma, the petitioners intend to revert to their previous position. What will happen? Suppose the time period is extended and at the same time you get a job over here, what will you do?
But in that event, some of them, because it is very few applicants were there before your lordships. In that event, perhaps that 1 or 2% would not be. That my lord, I cannot, my lord, assist your lordship to that effect. Perhaps he will not be going, or he may be going, my lord. It is up to his choice, because this the my lord, opportunity to sit for this examination has been given by the Honorable Supreme, which they have accessed. So my lord, they perhaps would be getting a chance. In that event, perhaps my lord, if he would have found that I cannot just my lord, address your lordship.
Listen, one thing. If you had reverted to your previous post, then also you could have appeared in the examination. And had you succeeded, you could have resigned and joined here. You did not do that.
This is not only my lord, this securing my lord, the position in the examination. As I have fallen from your lordships, several other situations were there. Because we have been, some of them have been given with the examination that copy
OMRs.
Answer sheets of this yes, assessment for the answer scripts of this board examination already. So we are in possession of them because we are my lord, examining the answer scripts now. So these are different jobs my lord, that right now we have been doing. But you can appreciate that. But we have been doing all these things together. And thereafter, my lord, can you appreciate that, as my learned senior my lord says, that 31st December you had given with a chance, but you did not go. My lord sees before expiry of why 31st of December. This is only because of the reason that 31st of the December, my lord, is the date
up to which, my lord, the Honorable Supreme Court has extended the time for completion of the examination. Secondly, before expiry of 31st of December, 29th of December, they themselves say that yes, it will be extended up to 31st of August.
See,
Then, my lord, what is happening?
the next day they change it.
Now, see the date. My lord, 30th
Yes.
December,
The next day, but then within one day, nothing altered much.
we could not even
What
do
is your stand? Why did you file the writ petition in February? What were you doing for the entire month of January?
I have, my lord, made representation in this meantime, my lord, because 31st December was an holiday.
So what?
1st January was a holiday. But after that, I had to make the representation.
2nd of January, you could have approached this court.
True, my lord, I did not do. I tried.
You
my lord,
waited for a month.
because they the 29th of December, they my lord, themselves extended it up to 31st August to December. I my lord, tried my luck by writing to them as well as my lord, visiting to their offices. Now, my lord,
No, this explanation is not a very very valid ground. But it is only because
because the time already,
Um,
you can appreciate my agony because my time is already expired in 31st of December. So I had to, my lord, try my luck by visiting their offices. When once the offices were reopened, then, my lord, I come make representations formally to them. Then, my lord, I come.
why don't you go before the Supreme Court and get it clarified whether you can continue till 31st of August or till the...
Only because of the fact of that the Honorable Supreme Court says that individual grievances has to be addressed before the Honorable Court. This is why
Yes.
it come before this Honorable Court.
The extension of time.
About extension of time, because, my lord, I have been, my lord, alleging my grievance before this.
Listen, you will say this is a fresh grievance. The other side will say the court time was extended by the Supreme Court and accordingly the state cannot do it.
When time was extended by the Honorable Supreme Court up to 31st of December. Lordship, can you appreciate the second extension of my window being opened to join, which was in November? They said, in spite of the fact they did not choose any other date, they chose 31st of December. Why? Because by 31st of December, they were supposed to conclude everything. Now, before 31st of December 29, they say, yes, we are because we are not being able to complete. Supreme Court has also granted time up to 31st August. We are extending your time or keeping the window open till 31st of August. Because this is the only feasible thing that could be done. Because we have been, because the Commissioner of School Education also knows, my learned senior will be addressing to your lordship to that. Because we have been given with several kinds of responsibilities. Now we have the answer scripts in our hands. But we are invigilators. Now,
will you look after the responsibilities or you look after your life and living?
so, my lord, these are and my lord, this is one of the aspects, and also, my lord, the fact that I participated in the examinations. Some of us have
That is the main thing.
My lord, these are all
It
factors.
was
My lord.
calculated risk taken.
My lord, these are the
Some may pass through, others may not.
Because the Honorable Supreme Court has given us the chance, because we are
Yes,
the
yes,
victim of
true.
the entire.
You can.
We are, my lord, the victim of the.
Nobody is stopping you.
Because we are the victim of the entire process. This is why, my lord, apart from everyone, we have been given the responsibility. The window under paragraph 47. Well, this is why, my lord, we have been given the chance that up to 31st August, December, you are there. Your window to get back to the employment, let it be there up to 31st August. They themselves did. Then, my lord, before 31st, 29, they say, since Supreme Court says 31st of August, you just go back to your employment before 31st August. This, subject to your lordship, this is the only feasible thing that could be done by them, which they have done, my lord. In my opinion, before your lordships, subject to your lordship's correction, if your lordship kindly sees once the 29th of December's order, what does it say? It is very vocal and very, my lord, reasoned by saying why I am extending the time to get back to your employment till 31st of August. Because the Honorable Supreme Court has extended that time. Kindly, my lord, turns to the relevant page, my lord. Otherwise, I would not have disturbed your lordship to this. Page number 75. In my opinion, this can't be more reasoned. But page number 75, it is 29th of December. If I could place, my lord, the Honorable Supreme Court of India passed an order on 3rd of April 2025.
This is the repetition of section paragraph 47. Yes.
Then, my lord, accordingly, the eligible candidates who had applied for allowing them to join in their previous service in the schools, primary or secondary, were allowed by you to join in their previous date. My lord, that is, my lord, second extension. In the meantime, 18th of December, the Honorable Supreme Court has extended the period of completion of the selection process till August 2026.
in miscellaneous subsection. After the Honorable Apex Court has passed the order of 18th of December, a good number of candidates may have prayed to you for extension of joining period in the old school by 2016 recruited candidate as per the order of the Supreme Court. Considering this situation, I am directed to advise you to allow extension of joining period if applied by the individual candidates. This is issued with the approval of the competent authority of the Department of School Education, Government of West Bengal. So this is the only reason.
1 minute.
Yeah, I'm
Page 77, please see.
Now see page 77. Grateful man. I'm sorry.
Yes, place it.
It says, in reference to the above, this is to inform you that as the issue of extension of time for rejoining in the previous service has been placed by some candidates before the Honorable High Court at Calcutta, I am directed to request you not to give any effect to this memo of such and such until further order.
Where is this
No
matter?
reference, nothing. This is
Where is
completely
this matter?
Justice Bibhash Patnaik, Surajit.
No, I am told me that it was before Justice Bibhash Patnaik.
Oh, whoever it is, was there any matter? Has any order been passed?
আছে এর মধ্যেই আছে আমি দেখাচ্ছি 31st ডিসেম্বর একটা অর্ডার হয়েছে
My ground of challenge before this honorable.
Sorry. 31st ডিসেম্বর অর্ডার হয়েছিল সুরজিৎ রয় মামলাটার নাম বিবেক আছে
পেজ
কপি আছে
যা সাহেব ওখানে 29639 একবার খুলে দিন না 29639
What did the court direct?
The court directed, my lord, here, my lord, this withdrawal of notification was under challenge. Affidavits were directed. In the meantime, if any right is accrued to the petitioners due to pendency of the writ application, it will be decided by the result of the application writ petition. Then the petition is permitted to continue for a period of 3 weeks. In the event he is not employed in any other place, but however subject to the final order of this writ petition.
এটার পরে 28 জানুয়ারি হয়েছে
Then
28
January opposition and interim order was extended till end of February 26.
No decision has been taken as regards.
No. But I've told you it's running in the list.
DPSC has filed an opposition saying that I'll join. DPSC opposition circuit bench DPSC একটা opposition আছে
দেখি next page.
তো দেখালে যেন অর্ডারটা 31/12
মানে DPSC এর অর্ডারটা ভ্যাকেশন বেঞ্চ
What was exactly the prayer in this petition?
আছে
আছে মামলা DPSC against it.
This is only an extension of interim order. What was the main prayer?
Is
31st December
দেখুন
সরি টা
The first prayer is to cancel the memorandum dated 30th of December 2025.
Oh, this is already under challenge.
Yes.
All right, 77. Suppose you are in service until 31st of August, you are saved, isn't it? You may not have reverted to your earlier job, but then since one matter is pending, let us wait and see what happens.
Because that order was passed in the honorable vacation bench, man.
Maybe,
So
but
could-
division direction for affidavit is there.
But could these two matters be taken up together, my lord? Because that is on the honorable vacation bench's determination.
অন্য মামলাটা কি
primary bench because it's the
Primary
DPSC mal
There is a direction for filing affidavits wherever the petitioner chooses. The petitioners will go there. Why will this court?
ওটা কার কাছে আছে
Why will
primary
Why will the court bring matters where they're running in the list of somebody else?
No, my lord.
No way.
Because the vacation benches matter.
It doesn't matter. It was issued on the 30th. At least somebody took the chance to approach the court in proper time. You came in February.
primary branch issue করে
You lost your chance ago. আজকে কোথায় ছিলাম বলুন তো?
লিস্টিংটা লাস্ট হয়েছিল 29 ফেব্রুয়ারি 19th। কালকে আবার থাকবে থার্সডে থাকবে।
Right. The learned advocate general submits that as the time limit fixed by the Honorable Supreme Court has expired, fixed by the Honorable Supreme Court, expired on 31st of December 2025. Accordingly, at this stage, the petitioners cannot be permitted to revert to their previous place of posting. Stop. Paragraph, it has been brought to the notice of the court that a separate writ petition being WPA number, একটু দেখে বসিয়ে দেবে,
2963